For the record, please.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan.
Good morning, Brian Jackson on behalf of Mr. Hall, who is present in custody for the continuation of his exam.
Look like we were last on the record just before Christmas on this. There was a request made for a video.
Correct. There was a request made for video as well as an additional witness who is here today to testify.
Was the video turned over to you, Mr. Jackson?
Yes, Your Honor, I've had a chance to review that.
So then the only thing we have is the last witness, so we have.
As well as an exhibit, Your Honor, that the people would admit prior to the witness.
Have you had a chance to see the exhibit?
I just saw it, and it just looks like a certified record.
Any objection to that?
No objection.
Looks like it can be received without objection.
May I approach, Your Honor?
Did you put a sticker on it?
There's a sticker, Your Honor.
Thank you, Mr. Buxton. All right, why don't you guys be seated? Let's go ahead and get started with the testimony. You have a witness that you'd like to call.
Yes, Your Honor. The people call Officer Chris Clue.
Chris.
Clue.
If I can get you to come around. That's fine. And before you see that, if I can get you to raise your right hand. Do you swear or affirm that the information is going to lie to the court?
I do.
Please have a seat. State your complete name and spell both your first and last name.
My name is Christopher Clue. First name Christopher. Last name Clue, Clew.
C-L-E-W.
Yes, sir.
You got that. Questions for Mr. Wood?
Yes, Your Honor. Thank you. Officer Clue, how are you employed?
I work as a patrol officer for the Lansing Police Department.
How long have you been employed there?
Just over 6 years.
Were you working on April 27th of last year?
I was.
In what capacity?
As a road patrol officer responding to calls for service.
I want to go back real quick. You said that you have been employed with LPD for the last 6 years. Were you employed somewhere before that in regards to law enforcement?
No, sir. This is my first law enforcement job.
Okay. What training and what kind of training did you receive prior to working at LPD?
Prior, I attended the Grand Valley State University Police Academy. That was in the spring of 2018, sir.
2018.
Did you receive education in regards to firearms?
That's correct.
Were you, so I want to go back to April 27th of 2024. Were you dispatched to the Sparrow Hospital on that day?
Yes, I was. A call came into dispatch for a male with a gunshot wound to the leg who came into the ER for treatment.
What did you first do when you arrived at Sparrow Hospital?
When I arrived on scene, just initially made contact with the medical staff, tried to figure out where the patient was located. Another thing that I did was typically when a gunshot victim comes into the hospital or anyone with a traumatic injury, their clothes are immediately removed and kept in the room. So I went and collected those items of clothing for evidence.
Did you notice anything unusual when reviewing that clothing?
I did. I was advised by medical staff that when the clothing were removed, one of them believed that they saw a spent shell casing in the clothing, and then upon examining the clothing myself, I located that.
What's the significance of the shell casing?
Well, the significance of a shell casing being inside the clothing leads one to believe that the gunshot was self-inflicted, because if someone shoots another person, the casing can be discharged out the right side of the firearm, somewhere on the ground or somewhere else. But but for a shell casing to remain inside the clothing means that the firearm was discharged either on the person's body, inside the waistband.
But that depends on the make of the firearm. True.
If it's a semi-automatic handgun, yes. Revolvers don't eject casings.
That is student.
Thank you, Your Honor. Did you see any type of blood on the shell casing?
I do not recall exactly if there was blood on the shell casing.
Do you recall the caliber of the missile,
I believe it was a 9mm shell casing.
which is a semi-automatic?
Yes, sir.
And you had a chance to look at the pants as well.
Yes, I did.
What did you notice? Did you notice anything unusual about the pants?
There was a exit wound around the knee area of the pants. And I also observed no entrance wound, or no entrance in the pants, which led me to believe that the firearm was discharged from inside the pants and the round only exited.
Was there any blood on the pants?
Yes, there was.
Did you notice anything else about the pants that would have led you to believe that the shot took place either inside or around the close contact of the pants?
Not specifically on the clothing. I was more led to believe this after talking with Mr. Hall and looking at his injuries.
So you had a chance then to talk to the individual that was shot.
Yes, I did.
And is that individual here in the courtroom right now?
Yes, he did.
Could you please identify him by a piece of clothing that he's wearing?
Yes, he's wearing the blue jumpsuit.
Your Honor, may the record reflect that the witness has identified the defendant.
Mr. Jackson.
No objection.
That it is positively identified as a person.
Thank you. What did Mr. Hall say when you had a chance to talk to him?
Initially, Mr. Hall said that he was out and about, going about his daily life, and somebody shot him. Don't know who, don't know where. He said he was somewhere in the south end of Lansing, and that was all he wanted to say.
Did you have a chance to look at his injury?
Oh, wait just a second. And that was all you wanted to say? Is that a quote or is that your sort of abbreviation of the conversation?
That's my abbreviation. I've worked many shootings in my time as an officer, and a lot of times we get uncooperative victims who either.
Let's just talk about this particular unit.
Yep.
What happened when you were talking to him about the nature of his injuries?
He said that he got shot. He doesn't know who did it. He got a ride to the hospital. Could not provide me an address of where exactly it happened. Couldn't provide a description. He said somebody pulled up in a car, shot at him, drove away, and he got a ride to the hospital.
Is that unusual in your experience?
That's a story I've been told many times, and a lot of times it can be misleading.
So what did you do as a consequence of being given that story?
Mainly my observations of his bullet wound. Based on looking at it, it was very evident to me that there was an entrance wound on the upper inside of the thigh and an exit wound near the back of the same left knee. Based on my training and experience, I've worked more shooting scenes than I can count, more homicides than I can count. I'm a member of our tactical team. I'm very familiar with firearms. Based on all my training and experience, it was a vertical downward shot where it entered the inside of his left thigh and exited the back of his left knee. Based on there only being an exit wound in the pants and no entrance wound, along with shell casing located in his pants, I confronted Mr. Hall about it and said, look, I'm not new to this. I know the game based on everything I got. gun went off in your waistband and you shot yourself in the leg.
As to Buxton.
Thank you, Your Honor. Did the defendant's story then change after you presented all of that to him?
It did, yes. He was initially uncooperative, not too pleased with me. After talking with him further, he eventually admitted that he was in possession of a firearm. He stated he was outside of his apartment. A car pulled up on him quickly, believing that it was someone attempting to shoot him. He reached for the gun in his waistband, pulled the trigger, and accidentally discharged the firearm inside of his own waistband, striking himself.
You said that this occurred outside of his residence. Where was his residence located at?
Correct. He initially could not provide an exact area, saying somewhere in the south end of Lansing. Our conversation ended with Mr. Hall being very uncooperative, getting up and hobbling out of the hospital. Looking through our records, through our report writing system, Talon, SRMS, him along with the female who was with him, they both had an address in Delhi Township. So at this point, I learned that it occurred outside of the city. I then contacted the Ingham County Sheriff's Office to pass this along to them and basically hand over the investigation as it was no longer in my jurisdiction.
I understand. Thank you.
Where did it get handed over to?
I responded down to the Delhi office of the Ingham County Sheriff's Office. I made in-person contact with 2 deputies. They collected evidence from me, and then we exchanged report numbers.
What type of pants were these?
Blue jeans?
So they would have gone all the way down to the ankles?
Correct.
Thank you. Nothing additional. Thank you.
Mr. Jackson?
You mentioned that you were a police officer for 6 years.
Correct.
Officer, correct?
Yes, sir.
And you mentioned that you have all this training and experience, 6 years worth, right?
That's correct.
Isn't it true that, like you said, some people don't want to cooperate with a shooting investigation?
Absolutely. I deal with it all the time.
And isn't it true that some people don't want to tell on the person who shot them?
Yes, that's something I've encountered.
So there's nothing unusual about that based on your training and experience?
If it was through and through from far away, then I could believe it. But someone's not gonna run up, stick a gun in another man's
I
pants
just
and
asked,
shoot
is
him.
that unusual? It's not unusual based on your training experience, right? For someone to either not cooperate or not want to tell who shot them.
It occurs. I'm not gonna say the exact percentage that I dealt with.
Is there anything about your 6 years that, well, let me ask you this. You are not medically trained, are you?
I've gone through TCCC through our tactical team, which is combat medic things such as tourniquets, chest seals, gunshot wounds, stabs, stabilization of life.
Does that have anything to do with trajectory of gunshots? Being able to look and tell? You're not forensically trained that way, are you?
I'm not a CSI officer, no.
And you're also not trained to look at fabric and decide what happened or didn't happen, are you?
I would say I'm not qualified to say absolutely. I'm just going off my observations.
And to further that, you have not been trained in the academy to look at fabric and decide what happened to it, right?
Correct.
And have you been trained to take a gunshot residue test?
I have not.
What would the protocol be for that?
I have no idea. That's nothing that we've ever done that I know of. Maybe it's something that CSI does, but it is not in our policy or procedure or standard operating procedures.
So you're telling me that in your 6 years in Lansing, you don't know anything about how to take a gunshot residue test?
It is not standard practice. I've never heard of it.
You never even heard of it?
No, I know what a gunshot residue test is. I'm saying it's nothing that we as officers do. I've never heard of it on a road patrol level at Lansing Police Department or any of the other departments in the surrounding area.
Do you recall when Mr. Hall said he will take a gunshot residue test?
I don't recall exactly. We spoke for quite some time.
Okay, so you don't recall that. And if somebody did request that, what would you do?
Again, that's not something that we do.
So what would you do in that situation if someone made a request of you? Is there somebody you would refer to, or?
No, I mean, it's something that we don't do anything with. I mean, it would be the same thing as if someone requested, like if we're in the middle of the night and someone says, I want the mayor to respond to the scene. Okay, I can't do that. That's not something that we do. You say, I want a unicorn to fall out of the sky. Can't do that either.
Okay.
Okay, well, let's just be clear. What you named, the mayor coming and a unicorn, is not related to your law enforcement duties, but you would agree that a gunshot residue is part of an investigative procedure.
I'm saying that it is not. That is not something that we as road patrol officers do.
And do you recall your conversation with Mr. Hall? Do you recall him saying that someone was playing roles?
I don't recall that statement particularly.
Do you know what that means, that someone's playing roles?
I do not.
You mentioned that you somehow thought that. Why did you think that the venue is in Holt, Delhi?
Because Mr. Hall stated that it happened outside of his apartment. He refused to tell me where he lived, his address on file for his driver's license, and our system in SRMS at the time showed in Delhi Township.
Do you recall Mr. Hall telling you and the police that it's over off of Long Boulevard by the two speedways in South Lansing?
I recall that.
And do you recall Mr. Hall telling you that it happened in South Lansing?
That was what he told me in his first statement, and then again changed his statement. So I was not apt to believe what he stated in his first statement because he had lied to me already.
And where did you get the address from that it was Delhi?
I got his address from his driver's license as well as the driver's license record of the female that was with him at the time.
Are there any other means where you could determine a person's address?
I can look in SRMS, which is our report writing system. If someone has had contact with the police and it shows their address under their file, but mostly that and lien, which is through the Secretary of State.
And which ones of those did you check?
I checked both of them.
So, and did they both say the same address?
Correct.
Do you know if he was living there at that time?
He was uncooperative and refused to tell me, so I had to go off of the best knowledge that I had at the time.
So you don't know if he was living there?
I cannot say definitively. Again, it's the best information I had to go off of.
And you don't know whether his injury happened there?
I cannot specifically say where his injury occurred because he refused to tell me.
But he did still tell you the apartments near the YMCA on the south side off of Long Boulevard. He did tell you that, correct?
Correct.
And that's not Delhi Township, is it?
It is not.
And do you recall saying that you did not want to go to the scene?
Pardon?
Do you recall telling Mr. Hall that you didn't want to go to the scene?
I do not recall that.
Would it surprise you? I mean, is that something you don't recall, or you don't think you did, or you're just not sure?
I do not recall.
Do you recall when he asked about taking a gunshot residue test, you said, "I don't want to do that"?
I do not.
Would looking at your body worn camera refresh your memory?
I believe it would.
Sure what the evidential impact will be of having that information, Mr. Jackson.
Well, Your Honor, as we're all aware, it's the investigator's job to do all the investigation. And first, the officer said that they don't do this type of investigation. But then when asked, he says he doesn't want to do that, but he doesn't remember it. So I was going to refresh his memory.
Refreshing his memory for what purpose?
Well, if he remembers him saying he doesn't want to do that, maybe he remember why he didn't want to do that. And it might, I mean, it has to do with his credibility and the whole investigation.
Mr. Buxton.
Your Honor, Officer Crew has made it very clear that his office does not do gunshot residue tests. That's not something that's done in the county. That's not something that, not standard practice. I'm not sure what any statement he makes in regards to that would be relevant to this investigation, as it's not something that's done. He's already made that very clear, Your Honor.
Mr. Jackson.
He said it's not something he's done, but I have reason to believe he says that he's not trying to run all that. And I think those are two different conflicting statements.
He said that he does not do that sort of work, that's not done by his department. So I'm gonna ask you to move on.
Thank you. Now, you mentioned that Mr. Hall, said that he shot himself. Is that your testimony?
Correct.
Isn't it true that he said, "I was getting the SHIT out of my pants and he blew it"?
Correct.
What did you interpret that to mean?
Well, I work in Lansing. I deal with people who talk in slang regularly. Getting that shit, upping it, pulling it out. There's many different terms for getting a gun. Blew it, means shoot it, shot it.
Okay. So you deal with slang, but you don't know all the slang, right?
No, but I'm familiar with those two.
Do you recall when he said that someone was playing roles and a tussle happened?
Objection, Your Honor, absent an answer. We've already went over this playing roles statement. He's already stated that he does not know what that means.
I didn't ask what it means. I said, do you remember that?
I'll allow for the answer.
Do you remember that he said that someone was playing roles and that a tussle happened?
Yes, I do.
And you didn't mention anything about the tussle in your first questioning, right? I mean, you didn't mention anything about tussle that he said.
We're here for a case about him having a gun, not that there was a physical altercation.
Well, you are saying that he shot himself. He's saying that something else happened, but you weren't there, right?
He admitted to trying to pull the gun out and shooting himself. I don't understand what
So
that has to do with this.
what words did he say that makes you think that?
I tried to pull that shit and blew it.
He said, "I tried to pull that shit and blew it."
Correct.
Are you sure?
That was my best recollection of the quote that you just provided to me.
How about "I was getting the shit out of my pants and he blew it"?
Sure.
I mean, don't guess, because I just want, if you don't remember, just say you don't remember. If you want to listen to it, I can play it for you.
I'm going off my best recollection, sir.
So, isn't it true that you don't know what the shit was that he was talking about?
He did not specifically state firearm, no.
So when you said that he said he shot himself, that's not what he said, correct?
That was my interpretation.
But you wrote it that he said he shot himself, but really you're not sure what he meant.
I cannot write a police report completely of slang. We try and make it clear and concise for not only attorneys, but judges and everyone within the process.
So when you wrote in your police report that he said he shot himself, he did not say that, correct?
He did not make that exact quote, no.
And you don't remember exactly what he said.
Correct.
Didn't he say that he had multiple witnesses that were there?
I do not recall that, but even if he did not provide any names or contact information.
Did you ask him for their names or contact information?
I don't recall.
If you heard that there were multiple witnesses at the scene, in your 6 years, would that indicate that you should follow up with that or something else?
Once I came to the understanding, shortly after my encounter with Mr. Hall, that at the time, I believe that this incident occurred outside of the city. I'm not going to do the entire investigation. I'm going to take what I have, and I'm going to pass it along to the department who has jurisdiction over where the
Did
scene
you
occurred.
have his pants?
I did. I drove down to the Delhi office and
Just
handed them off.
hold on for my next question. Did you examine the pants?
I did.
And how many holes were in the pants?
One,
Which indicated what to you?
it was exit wound by the back of his knee. There was no entrance wound in the pants down the inside of the upper thigh.
Okay.
You mentioned one hole in his pants.
Correct.
Isn't it true that his pants had other holes in them?
What kind of holes are you talking about? I mean, were these like some sort of vintage jeans or what are we talking about?
I believe so.
None of the other holes appeared to be bullet holes, and there was none, from what I recall, around the area of the initial entrance wound on the inside of his upper left thigh.
So, based on your memory, do you or don't you recall other holes in his pants besides the one that you think was caused by
That's a
bullet?
fair question, Mr. Jackson, because you just indicated that there are multiple based on the design of the fabric.
I'm not the witness. I just was answering your question.
I get the answer. I got the answer that I was looking to try and determine what was going on from his vantage point. But if he's got multiple points of where he could have entered that, but only one where it was actually one consistent with the bullets, I think that was probably where we're at.
So you mentioned that a shell casing was found. Did you have anything to do with that shell casing? What did you have to do with the shell casing?
It was left with the clothing that I collected it, so I also collected the shell casing.
Where did you find it at?
The clothes were in a pile in the corner of the hospital room, and when I picked up the clothing, I searched it, and the shell casing was located in them, within the pile.
So was it loose in the pile? Was it,
It was within the pile.
so not like, okay, I'm just trying to figure out, because you're the one
It
that,
wasn't in a pocket, that's what you're trying to determine.
I mean, that's one thing I'm trying to determine.
It was not in the pocket.
So can you help me understand? You saw a pile of clothes in the corner. Did you take one article at a time? Did you pull the whole thing up and it fell out? Like, how did it found?
First of all, do you have a recollection of how you proceeded to gather things?
Yes, I do. Every time I respond to these things, I do it the same way. You pick each item of clothing off the top, examine it, fold it nicely, put it in an evidence bag. So when I picked the pants off of the top of the pile, shell casing fell out. I don't know exactly from where, it just fell from the pants on top of the other clothing.
Did you ever verify that Mr. Hall lived at that address in Delhi?
I was unable to because he was uncooperative and he left.
And if somebody was on parole somewhere and their address was there, where would you find that information at?
As far as following up with the parole officer,
Well, I guess that's my question. If somebody is paroled to an address, how would you learn that address?
I have not specifically gone through parole officers. That's something that can be done by our detention officer lien operators or officers in special assignments such as SOS and BCI, which I am not a part of.
Isn't it true that Mr. Hall said that he was at the residence where he was paroled to?
I don't recall that.
And if he did say that, couldn't you then use that information to find out what residence he was paroled to?
Yes,
That didn't happen, did it?
it did not.
When you're doing an investigation and you're interviewing somebody, in this case, Mr. Hall, and Mr. Hall tells you what happens, and how many, I guess, how many times will you ask somebody for an answer if you don't like the answer that you're receiving?
You have objections?
Not quite sure the relevance of that question.
I'm not sure if that's actually, what is that? I mean, not quite sure about whether they can ask that question.
I don't see the relevance to that question, Your Honor.
All right, so you have an objection.
I have objection to relevance.
Mr. Jackson.
Yes, Your Honor. Based on what I've watched, I saw a lot of questioning and a lot of answering, but yet not acceptable. So I kind of want to know where,
You saw a lot of questioning.
Mr. Hall. I guess my question is, how many times can a person tell you what happened, Mr. Hall, before
So
you are
we're
satisfied?
trying to actually have me address what the concern is that you raised as it was sort of objected to by brother counsel. So if you'd like to do that first before you try and turn the question back to him.
Yes, Your Honor, it's relevant because it's what the defendant allegedly said, and my question has to do with the interrogation of him and how that normally plays out. Like, I mean, that's my question. How many questions can one officer ask a person and get an answer before you either take it or leave it?
Mr. Fulton.
I still don't understand how this hypothetical is relevant to the question that took place.
The objection is to relevance.
Relevance and, yeah, relevance, Your Honor.
All right, I'm going to sustain the objection and ask Mr. Jackson to move on.
Do you have a body worn camera policy that's written with the Lansing Police Department?
We do, yes.
Do you know it?
I could not recite it verbatim, but I'm familiar with it.
Is there any provisions about interviewing a person that's seeking medical treatment with your body worn camera on?
There is nothing that says we're not allowed to do that.
From your memory of the policy or just from a guess?
From 6 years of experience and from never running into a single issue of interviewing somebody in the hospital with my body worn camera activated.
So are you saying that there is no policy about that, or you're not aware of it and haven't had any problems with it?
I'm saying there is nothing in my knowledge or my reviews of the policy that state that there would be an issue with that.
You just said you don't know the whole policy though.
I'm saying I don't know it verbatim. If you have my policy, I would gladly review it.
Is there anything in your training that, I guess, is there anything in your training that would be problematic with interviewing a person who is in the hospital with a gunshot wound?
If they're not actively receiving medical treatment from personnel, no. If someone's actively getting CPR, having tourniquets put on, or being bandaged up by doctors, I'm not jumping in to ask questions, which is why I didn't speak to Mr. Hall while he was back receiving scans, and I waited for him to come back out to the hallway bed, and there was no medical personnel actively working on him.
So when you question him, where was that at? As far as like the hospital,
He was laying in a bed in the hallway of the ER.
weren't there doctors or nurses around him?
There's always doctors and nurses around the hospital.
Around him for his attention?
In and out, yes.
And he had various medical things attached to him, right?
Yes.
No further questions.
Yeah, that's their boss thing.
Briefly, Your Honor. On cross-examination, it got brought up that the defendant's statement was he was getting that shit out of his pants. Does that sound correct to you?
Yes.
What were you two talking about at the time he made that statement?
We were talking about guns and how he got shot.
So then, based off the context clues, what did you believe the word shit to be in this context?
It was completely relevant to the conversation of getting shot and guns and shootings and bullets for that shit to mean gun.
Thank you. Nothing additional, Your Honor.
Thank you for your time. Appreciate it.
Thank you.
You gave me that water.
I appreciate it.
Now, further witnesses, Mr. Thurston.
No, Your Honor.
So, people resting at this point.
The people do rest at this point.
Mr. Jackson, are you continuing to call witnesses?
No, Your Honor.
Then I guess we're at the point of having argument.
In regards to count one, the jury instruction is Michigan Criminal Jury Instruction 11.38A. And in regards to count two, the felony firearm, the elements can be found in Michigan Criminal Jury Instruction 11.34.
Okay.
Your Honor, we have met our burden and we ask that you bind over on the charges in the complaint at this preliminary examination. In this case, the defendant has been charged with, as I stated, one count of possession of a firearm by a prohibited person in count one, and in count two, felony firearm. In regards to count one, possession of a firearm by a prohibited person, as I stated, the elements can be found in Michigan Criminal Jury Instruction 11.38. The first element is that the defendant knowingly possessed a firearm in this state. You heard from Officer Clue in this case that he had a chance to talk to Mr. Hall. Mr. Hall, on April 27, 2024, was brought into Sparrow Hospital. He reviewed the clothes that Mr. Hall was brought in on, and there was a single hole in the pants. You additionally heard, Your Honor, that there was blood on these pants, and that there was a shell casing that was found by the jeans as well. Additionally, Your Honor, you heard that the cell casing was consistent with a semi-automatic, which you heard from Officer Clue in his training and experience is a item that gets discharged from the side of the gun and would be inside of the clothes if the gun was discharged inside of the clothes. Additionally, Your Honor, you heard that Officer Clue had a chance to see the defendant's injuries. The defendant had 2 holes inside of his leg, so both an entrance and an exit wound, one in his upper thigh and coming out of his knee area. And the exit wound was consistent with the location where the hole was on the pants that Officer Clue had seen previously. After talking to Mr. Hall, the defendant, Mr. Hall eventually admitted after they were talking about guns and shootings and things of that nature that the defendant said, I was getting that, excuse my language, Your Honor, shit out of my pants. And as you heard from Officer Clue, that is lingo that he hears in his training experience. That means that that is a firearm. And additionally, from the context of the conversation, it was clear that that word meant gun. So the defendant did knowingly possess a firearm in this state. Additionally, when he made this statement that matched up with the evidence that the officer found, he stated that it occurred at his house based off his driving license and driving license record to be in Delhi Township. The second element is that at the time the defendant had previously been convicted of possession by a prohibited person, or been previously convicted of a specified felony. And that specified felony, Your Honor, can be seen in People's Exhibit 1 that shows a judgment of sentence.
That's the paperwork that you gave me.
Correct, Your Honor. They show he has been convicted of a specified felony.
And which one are you referring to? Because
There are 2, Your Honor, counts 3 and count 4.
Okay.
And while there are other elements, Your Honor, that can be seen in this jury instruction, those are only read to the jury and taken into consideration if the defendant offers evidence that this has been more than 5 years since the completion of the sentence in its entirety. And at this point, Your Honor, the defense has not offered any. In regards to count 2, felony firearm, as I stated, the element can be found in Michigan Criminal Jury Instruction 11.34. The first element is that the defendant committed the crime of possession of a firearm by a prohibited person, which I just finished arguing on in regards to count 1. And the second is that at the time the defendant committed the crime, he knowingly carried or possessed a firearm, which, as I just argued, it was clear the defendant did have a firearm based off the statements made to the police, as well as the wounds found on the defendant and the holes found in the defendant's pants. Therefore, I ask that you bind over on the charges in the complaint. Thank you.
Mr. Jackson.
Thank you, Your Honor. I'm going to keep my argument to a very specific requirement here, and that's venue.
Okay.
This preliminary exam was held in 2 parts. The first part was an Ingham County deputy who testified that he received information. He looked at the clothes, but he also received information that it was at the Doncaster address, and that they went there and that they canvassed. They couldn't find anything. They talked to the neighbor, didn't hear anything, and that there was no evidence of that. We hear from the officer today, who was the one who took the information that from Mr. Hall, that it allegedly happened that Mr. Hall was at his residence in South Lansing, at his residence by the Southside YMCA off of Long Boulevard, where there's 2 speedways, City of Lansing, not Delhi Township, and that the officer today testified that he doesn't know where it happened and he doesn't know whether or not Mr. Hall lives at that place. So, keeping the argument to venue, there's no evidence on the record that the venue is correct here. In fact, there's some evidence on the record that the venue is wrong.
So I just wasted a couple hours of my day. That's what you're suggesting.
I don't know if it's wasted, Your Honor, but I can tell you that the venue is not proper here and that without proper venue, that we can't find over, and we would ask that you make those findings today.
Mr.
Yes, Your Honor. I want to start off first by talking about the statements made by the previous witness. I do not have in my notes,
No, Mr. Pinatar.
and yes, with regard to Deputy Pintar, I do not remember any questioning in regards to the canvassing of the area previously. So I'm not sure if that was admitted into evidence. Regardless of that fact, Your Honor, as you heard from Officer Clue today, the defendant stated that this took place in front of his apartment. The Officer Clue ran the records, ran his driving license and driving license record that both stated that the address was in Delhi Township.
So I have a note that says that Doncaster was the location of the shooting. That was according to Williamston Police Department. That is inaccurate. According to that I have. That's from Joseph Pinatar from cross-examination.
It's been a while in regards to those statements. And it would have been the sheriff's department, not Williamston.
But apparently that's where Pinatar was working. Says that he works for Ingham County Sheriff's Office for a year and a half, but
So yes, the area canvass did take place on Doncaster Avenue.
okay, that's what I'm saying. So basically what you're saying is that he is in the proper courthouse today.
I would say the venue is proper, Your Honor, based off the statements of the defendant as well as Officer Clue's investigation of his driving license record, which states that he did live at that Doncaster residence in Meridian Township.
Actually, that's all.
Or in Holtz. Yes, you're right. I apologize, Your Honor.
All right, I'm going to rule that there is in fact jurisdiction for us to handle the case because his actual, what he gave us, this is our sort of handy dandy, not public information, that clearly shows that he lived in Fulton at the time that this occurred, which would mean that this courthouse would be correct in terms of our ability to be able to decide the case. But in deciding the case, I find that I believe that the defendant was in fact appropriately charged with the offense of possession of a firearm by a prohibited person. His criminal jury instruction that we've been talking about, 11-38. And for the reasons that we've just been talking about, as I was getting this out of my pants, and it shows that the defendant did in fact possess a firearm while in Delhi Township in County State of Michigan. I further find that under criminal jury instruction 11-34 that this is a felony firearm charge. The conviction is based on his possession and that he normally carried that firearm at the time that it was discharged while he was in Delhi Township. So I'm finding over with regard to both other charges. Anything else further for the record at this point, Mr. Buxton, as it relates to conditions under which Mr. Hall is being held?
Not for the people, Your Honor.
Ms. Jackson? Anything else further?
No, Your Honor.
All right, then the matter is bound over to circuit court on the charges and complaint. And we will see what happens with the case. Mr. Braun, in this matter.
I believe it is a cash surety bond, but I'm not entirely sure.
Let me just see if I can look into that. Looks like the bond is only $5,000. That it was actually stated at October 29th, 2024.
And he is currently incarcerated in the Department of Corrections.
Oh, Gordon's already got a different charge, so that's.
Actually, Your Honor, it is this. He's on a parole hold because of this.
Okay. So, any reason to address changing that, Mr. Buck? Comfortable with the fact of Drees?
Once again, our people have no argument or objection in regards to the first file.
So will we continue that $5,000? All right, gentlemen, thank you so much for your time. I appreciate it. Thank you to the transport officers as well.
It's his discovery. That's the way we gotta do it now. It's gotta go through the mail.
We're now live streaming on YouTube. This is Judge Dulce Madrigal. I'm hearing cases out of Hays County today on Thursday, September 12th, 2024. At this time, I will recall cause number 241484 with the parties non-custodial parent Nikki Nicole Seaton and the custodial parent Marshall Lee Leverett. I did have an earlier hearing with you all. I recognize that, and that was specifically and only to release Joanne Salazar as Ms. Seaton's attorney. Y'all went back to negotiate, and you're back in my courtroom for a record. Let me see, Ms. Seaton, go ahead and announce yourself again, your full legal name.
Nikki Nicole Seaton.
Mr. Leverett, same for you.
Marshall Lee Leverett.
Now, this is a second record, but just an abundance of caution, so it's all complete on one record. I need to swear you back in. Miss, if you'd raise your right hands for me. Do each of you swear to tell the truth, the whole truth, and nothing but the truth, Ms. Seaton?
Yes.
Mr. Leverett?
Yes, ma'am.
Thank you. I won't repeat everything I said earlier, but you know that I am a court of record. I've got a digital recorder. Make sure all your answers are verbal. Same thing, no ahas or ahs, yeses and nos, and no nodding or shaking your head. The live stream issue, I've explained earlier, we are live streaming on YouTube at this time as a requirement that the courts are open to the public. And I think you probably haven't forgotten that part, so I won't repeat myself on that. And again, I'll remind you, do not record. I have the official record, and any recordings by anyone else would be considered a violation of law, subject to contempt of court, punishable by a fine and or a jail sentence. That applies to you all here in the courtroom and or anyone observing through the YouTube app. So let's go forward, Mr. Asif. You all negotiated after that original preliminary hearing, and where do you stand at this point? And announce yourself first, Mr. Asif.
Yes, Your Honor. This is Assistant Attorney General Maz Asif for the state of Texas. The parties have agreed on some terms and they've disagreed on other terms, which I'll just be going through one by one. On the matter of conservatorship, both parties are requesting to be named the custodial parent, but they have agreed in other respects. They both agreed that irrespective of the custodial determination to a joint managing conservatorship, and they've also both agreed that if named the custodial parent, that there will be a geographic restriction limiting them to their current county of residence plus all the surrounding counties. If Ms. Seaton is named the custodial parent, that would be Travis County and all the counties surrounding it. And if Mr. Leverett is named the custodial parent, that would be Hays County and the county surrounding Hays. With respect to possession and access, the parties disagree. Ms. Seaton, Your Honor, I have submitted to you two exhibits. It's the parties' proposed visitation schedules. Ms. Seaton is requesting a 50-50 split. Mr. Leverett is requesting something more akin to a 70-30 split. I figured it was easier if you just had their proposals in written form rather than having them testify to all the nitty-gritty details.
Did you send it to the CSC?
CSC 18, yes, Your Honor.
Okay, thank you.
The state has no position on the issue of conservatorship or possession and access. We're asking, other than we're asking for a judgment in the best interest of the child. With respect to the medical issue, parties have reached an agreement that the child will be on Mr. Leverett's health insurance and Ms. Seaton's dental insurance. Miss Seaton has also been sending Mr. Leverett $95 a month towards the health insurance costs, and the parties have agreed for that to continue. So we have an agreement there with respect to the medical situation. With respect to child support, Mr. Leverett will be requesting child support if named the custodial parent. The state has calculated guideline child support in that case to be $657 per month. We would request for payments to begin on the 1st of October. Ms. Seaton, if named the custodial parent, she's requesting child support only if there is no 50-50 split, Your Honor. If Ms. Seaton is named the custodial parent and the visitation schedule is not 50-50, if she has the child more often, she will be requesting she will also be requesting guideline child support, which the state has calculated to be $895 a month, with payments to begin on October 1st, 2024. Parties have agreed to waive retroactive support. So irrespective of the custodial determination, neither party will be seeking retroactive support. Neither party will be seeking non-disclosure of their contact information. And finally, Your Honor, the state will be asking for an awarding of court costs against the non-custodial parent, whomever that you determine they are. We're asking for that. Both Ms. Seaton and Mr. Leverett have stated that they, if named the non-custodial parent, they are requesting that court costs be waived against them.
Okay, I know that there's a policy, and I don't know if you're aware of it, being a more recent arrival at the AG's office, that if somebody has had the benefit of your services as a custodial parent, and I don't know if this is the first time the case was filed and there's only one custodial parent ever, then Mr. Leverett, we can't charge court costs against him. It would be for the non-custodial parent. So even if it flips, it doesn't matter. It goes with him if he's the custodial parent and y'all are providing services to the person as a custodial parent.
Understood, Your Honor.
If you understand that and can tell me if mother's never been a custodial parent or has been a custodial parent and flipped or not, that's fine.
I believe this is the first setting, Your Honor, so we don't actually,
Okay.
Mr. Leverett's name is custodial parent in our records because he filed the application, but there hasn't been a determination of custody.
Okay. So you filed a suit affecting, it's a SAPSR and with an acknowledgement of paternity, or is it something else?
It's an original petition in the suit affecting the parent-child relationship, Your Honor.
But there was an AOP that was signed for the child?
Yes, Your Honor.
Okay. And so that's not an issue, and there's no DNA or any of that stuff that's relevant.
No, Your Honor, parties are not contesting paternity.
And they'll tell me names and birth dates later, but can you at least tell me is one child and how old, or how many children, Mr. Asif, roughly?
My understanding is there's one child between the two parties. I'm sure they can correct me if I'm wrong, but I believe she's 10 years old at this point.
10? Okay. Okay, usually these kinds of cases are much younger children, but okay, I get it. Then we'll go forward. And you're going forward without lawyers, and that is your intent and request, Ms. Seaton?
Yes.
And same for you, Mr. Leverett?
Yes, ma'am.
Okay, I am a court of record, however, and I am a court of that if of a not of appeal, but you can appeal from my court. So if you don't like what I do, I need to put you on notice that either of you can appeal. It's called a de novo right of appeal, which means that you're basically starting over in a higher court. That would be the elected district judge that is assigned to this case. And so it's possible one of you may be wanting to file and start over, maybe with a lawyer or not. However, I caution you, if you want to do this and you want it to stick, that you're prepared, and that if we go forward, you're kind of stuck with my ruling unless and until you make it to another court, and it takes time and energy and maybe money by hiring lawyers. And if you don't want to do that and want to be better prepared on another day, I'm willing to do that as well, including with limited witnesses. Or even a lawyer again, because Ms. Seaton, you released your lawyer this morning. And it's an important issue, it is. And I do it all the time. And I do it with two people with the he says, she says. But I also recognize that lots of things that happen after the fact of the trial in my court. And I'm trying to prevent much of that, because it is complicated and confusing, especially if the child gets flipped back and forth between different decisions with different courts, and already with the age of 10, you're going to tell me this whole history, and you may or may not agree to what happened, and then I get stuck deciding what happened and who I believe, and even if it's y'all don't agree to what happened. So I caution you to, it is a big issue, especially with a 10-year-old. So having heard all that, Ms. Seaton, you still want me to hear it right now, today?
Yes, I'm fine with that.
And Mr. Leverett, same question. Okay, let's go forward. Mr. Seif, he's gonna call witnesses. He gets to decide in what order. What I'm telling you is that because even with a court reporter, if there were one, with a digital recorder, it's even worse. If y'all start talking over each other, the tape is gonna be all garbled and messed up, and I can't hear you. I'm just gonna stop you and say one at a time. But what we do is he calls a witness. That witness is the one that testifies. I'm gonna ask the other person to be silent. If you have things you want to respond to, write them down, or make sure your memory's good so that you remember what you want to say when it's your turn, but don't interrupt. The only interruption would be a valid legal argument or objection or something like that. Otherwise, you can't jump in and tell your side in the middle of somebody testifying. And when it's your turn, you get the same courtesy of no interruption. And again, I'm gonna stop you, and it's gonna take longer if I have to do that, to start all over and admonish you not to do that, because that's the way it works. One witness at a time without interruption, and then the next witness at a time without the other's interruption. Okay, Mr. Asif, you may call your first witness.
Yes, Your Honor. I'll start by calling Mr. Leverett.
Okay.
Mr. Leverett, could you please state your name?
Marshall Lee Leverett.
Could you please state the name of your child?
Tegan Elizabeth Leverett.
Who is the mother of your child?
Nikki Nicole Seaton.
And what's your relationship like with Ms. Seaton?
For the most part, it's pretty good. I don't think that it's terribly bad. I don't think that we have a bad co-parenting relationship. We do disagree on things, which is normal. I do try my hardest to do what is best for Tegan in her education and her mental health and her life. And honestly, for a long time, I felt that Miss Seaton did as well. I do know that certain things have happened that have maybe steered her away from that, but I just want what's best for my daughter, and my daughter is a lot like me. She favors my actions, she favors me, and I just want her life to be good, and I want it to be as normal as possible.
Mr. Leverett, is your daughter currently living with you?
Yes, sir, she is.
And what's your living situation like?
I have a house in Kyle next to her school, who I live with my who lives here as my fiance, and our daughter who's 2, Tegan's sister. Tegan is with me the majority of the time. I have Tegan in after school sports. She plays select volleyball here at a local select volleyball place. I try to have her, she hangs out with her friends. She's with me a lot of the time.
Okay. Are you in agreement that irrespective of custodial determination today, are you in agreement that to a joint managed conservatorship going forward?
Meaning is this the information?
Yes.
Yes, sir.
Are you in agreement if you are named the custodial parent to a geographic restriction requiring you to live in either Hayes County or one of the surrounding counties?
Yes, sir.
Okay. Can I please direct your attention to you sent us a proposed visitation schedule. Does that ring a bell?
Yes, sir.
Okay, sir. Could you please explain to me, why do you feel this visitation schedule is in the best interest of your daughter?
I feel like it's in the best interest of my daughter is because this is the schedule that Tegan's been on since she moved with me in March 13th was the day she moved with me in 2023. This is the schedule that we've stuck to. And I've found through not just me, but her teachers, her academics, that this is the schedule that's best worked for her. I don't, as much as before we got to court and before there was anything, as much as her mom ever wanted to get her, I've never stopped that. I've never, there's been a few times that Tegan has gotten in trouble at school that she was going to be grounded or something. And I have kept her from going to her mom's, but we were in agreement that that was better for her at the time of what was going on. I, this is her schedule. This is what she knows. This is what she's known for the past year and a half. I mean, since March of last year, this is the schedule. This is the schedule that she knows um, is what we currently do.
Okay.
And that is pretty much my proposed deal. The only thing that would be added that would be any different is her mom would, I mean, she could do it now, but she would be able to come and get her on a Wednesday after school for dinner or whatever. That is the only difference that would be, like, I guess, set in stone with my proposed agreement. With my proposed agreement, I think that everything is, it's this, like I said, it's the same schedule Tegan has been on. There's really no difference in schedule.
Okay, Mr. Leverett. It was March 2023, you said, when your daughter moved in with you?
Yes, sir. March 13th, 2023. Yes, sir.
And what was and how did the co-parenting arrangement work prior to then?
We were week on and week off. Before that, it was a little trickier because I was diagnosed with cancer in October of 2022. I was diagnosed with lung cancer. So from like October, there were a couple times that I was not okay mentally, and I don't want to say but Tegan stayed with her mom a little bit more because I didn't know what was going on with my cancer, and I tried to keep it from Tegan as much as possible because I didn't want her to suffer from. I wanted to have a plan of what was going to happen with me before we kind of agreed to introduce her of me having lung cancer.
And what's the status of your lung cancer?
They removed my lung February, and I'm fine. I'm cancer free.
Okay. You stated prior you had some concerns regarding Miss Seaton. Would you care to elaborate?
She moved fairly last year, and I just don't want that to happen with my daughter. It happened with me when I was a kid, and I suffered a lot emotionally, educationally. I was held back because my mom also moved. She currently lives in the same house that she moved from, so I'm not sure why she moved. It's none of my business, but those would be my concerns. I want Tegan to be on as much of a consistent schedule as possible. That's all I've ever wanted.
Okay. If I'm understanding this correctly, with respect to your daughter's medical needs, the current situation, she's on your health insurance and Miss Seaton's dental insurance. Is that correct?
It's a little complicated. She's on both of our dental insurances right now. When Miss Seaton started, we kind of lucked out because we had taken Tegan to the dentist. Her mom took her to the dentist probably a year before that I did, and they said that she would probably be, if I remember correctly, it could be about 2 or 3 years before she got braces. But when I took her to the dentist, they were pretty adamant, like she needs to have this done pretty quickly because she was starting to lose a lot of gum, having like gum resuscitation on her bottom. So they wanted to do braces, but then they kind of put it on pause because she had a couple teeth that she needed to lose and they wanted her to grow in. So we agreed to put her on my lower dental insurance for the year until so I have her on dental insurance, and then when I took her, it kind of worked out in just a coincidental way that her mom had just started another job and could add her to a higher dental insurance. So we decided that it was best for her mom to add her to that higher dental insurance because I couldn't open enrollment for my insurance had already passed.
Is there a more comprehensive dental insurance plan available to you, sir?
Yes, sir, there is. And with the court order, I checked and I can have it I can have it up with the court order. I can do it immediately with that order. I can go on a higher plan, which I think would be cheaper for myself and what Miss Seaton is currently paying if we split the cost.
It's my understanding that you would like for the current situation where that you described, and for Miss Seaton to continue to pay you $95 a month towards the health insurance. You'd like that to continue, is that correct?
Yes, sir.
Okay. You're requesting child support if named the custodial parent, is that correct?
Yes, sir.
Do you have any objection to the guideline figure of $657 a month?
No, sir.
Okay, sir. Are you employed?
Yes, sir.
What do you do for work?
I'm a glass estimator at the Glass Guru of Austin. It's a kind of a fancy word for I'm a glass. I measure foggy and broken windows for work. I don't want to say a salesman because I'm not a salesman. People have a broken window or a foggy window, they call me, and I've been in this trade for almost 10 years since Tegan was born.
And what's your income?
I make about I think I can't remember what the figure we came up with, but I think it's about around 6,000 a month. I think it's 6,300 a month.
Okay. Thank you, sir. It's my understanding you're not requesting retroactive support, is that correct?
No, sir, I'm not.
You're okay. Do you believe it's my understanding you are also not requesting non-disclosure of your contact information, is that correct?
Yes, sir.
Do you believe Miss Seaton, Miss Seaton, do you believe she's not a threat to you or your child?
Yeah, she's not a threat. No, sir.
Thank you. You've requested that if you are named the non-custodial parent, or my apologies, actually, Judge Match, I had that issue mixed up. Judge Matchko corrected me. My apologies. Okay, you would like to be the custodial parent. Why do you feel it is in your daughter's best interest for that to be the case?
Like I stated before, me and Tegan are a lot alike. We have the same manner. She's just a lot like me in a sense of how I grew up, and she has ADHD like I do, so we kind of have more of an understanding. And like I said, I mean, the main thing is her schooling, her education, her behavior. It's gotten significantly better since she's been here, and she's been here. I mean, in 2023 from March, she was here 223 nights, and from January 1st of this year to August 12th, she slept here 164 nights. Obviously that data is a little off now because we're in September, but this has been her schedule. So I feel like if anything switched, it would really affect Tegan. I live honestly about a mile from her school. I take her to school every morning. Her friends are here, her volleyball's here, her sister's here. Her life is in Kyle before, and that's what I think that it would be best for Tegan to continue on that schedule because she doesn't really do that well with change. I've always been very honest, and if I felt like her mom could provide her a better life, I would tell you that her mom could provide for her a better life than I can. And I'm not being disrespectful, or in the best interest of my daughter, I don't believe that that's the case. And I mean that with all due respect, but I just feel like her life and her well-being is better when she's with me most of the time.
Mr. Leverett, do you have any other children?
Yes, sir, I do. I have another daughter. Her name is Harper. She's 2.
Does she live with you?
Yes, sir, she does.
Okay. And your fiance and your elder daughter, what's their relationship like?
They get along great. Tegan loves Leslie. Leslie loves Tegan. I mean, they get along really well. My fiance is a really good woman. She's always had Tegan's best interest. Tegan was in dance. She's never overstepped her boundaries. She's never tried to take Nikki's spot as Tegan's mom. She always encourages Tegan to respect her mom and do things with her mom. And Um, you know, for instance, Tegan had a dance recital, or Tegan, you know, Leslie bought them tickets to a movie. Tegan wasn't seeing her mom, and Leslie would tell her, "Hey, you want your mom to come and do your hair, or do you want your mom to do these things?" She always puts Nikki's motherhood with Tegan before her, because she has a child. And I feel like that's the way that she would want it to be as well. If me and her weren't together, that she would want her motherhood to be put first. So I think Leslie really loves Tegan, and I think that Nikki would agree that they really have a really good relationship that um we should both be thankful for, because Leslie is a good woman. She's really good to Tegan.
Um, I'd like to circle back to the schedule that you proposed. You're stating that that's what's currently occurring. Is that correct?
Yes, sir. The only difference is, like, in the summer, I don't pretty much, like, a schedule restriction to me is I don't need, if her school schedule could stay the same, and I wish that I could have talked to Miss Seaton about this before, she could stay with her mom in June and July, the whole summer, to catch up on time. Um, I'm not trying to take her away from her mom. I'm just trying to do what's best for her in her education. She's struggled a little bit when I first got her in March of 2023 with reading. I really got her up. Um I'm very proactive in her life. I really try to get her on the right track with her her reading and her math, because she is struggling a little bit in math now. But I've been working towards hiring a math tutor to we're in the middle of a lot of things right now with Tegan. She needs braces. I need to get her this math tutor. So yeah, I just think that sorry, I forgot your question, but yeah, I mean, I don't have a set schedule in the summer. Her mom can have her 2 weeks on, 1 week off, whatever needs be for her mom to catch up
And
on time that she wants with her without being in school. I have no problem or objection to any of that. So that, I think it says there's a mistype, like a misprint in the schedule where it says 1 week on and 1 week off. It was supposed to say 2 weeks on and 1 week off. The only thing I would ask is, if that is the schedule, if in August, that's what I try to do this year, that's what I did the year before in 2023, was like, Tegan usually starts school about the second week of August. I just asked that, like, the week of August, if I can go back to like a school schedule so I can get her acclimated to her schedule for school. That would be the only qualm with August. But June and July this year, when she was out of school, it's free reign for her. Go stay at your mom's for 2 weeks, 3 weeks. It's summer. Whatever you want to do is whatever you want to do is totally fine with me, as long as your mom's okay with it. And it's
okay,
totally,
Miss. Sorry, carry on.
yeah, I mean, that's it. The only thing we kind of disagree on Tegan being old enough to stay by herself. I don't think that she's old enough or mature to stay by herself, but I'm also a protective dad. And I don't like that, but when she's with her mom, there's not really much that she's her mom. I can't.
And how have these visits been going when Miss Seaton would come and for her periods of possession? How's that been going?
It goes good. Tegan has a good time. She loves her mom. Her and her mom are close. There was a little bit in 2023 where her mom was going through a rough patch in life, which totally understand. I think their relationship has gotten a lot better since then. I have known Miss Seaton for a long time, so I am not shy of telling her if I don't think that she's being up to par for what Tegan deserves, and I expect the same respect from her. So it got a little choppy there because I was advocating for my daughter, but I do think that their relationship has gotten a lot better, and uh, I think that Tegan is in a better place with her mom than she was this time last year.
You stated Miss Seaton was not in a good place. Do you care to elaborate on that?
She was working a lot before she lost her job. She was working a lot, and that's why the schedule looks like, and I didn't want to share every text message that we have, but that's why in 2023, that's why a lot of the time, if you look at the exhibit that I sent into 2023, Tegan was with me. She was working a lot, which I understand. But there were a lot of times after a while that I would tell her like, hey, Tegan misses you. I don't want to keep lying to her, keep telling her these excuses. Like she's old enough now to where she understands where you need to talk to her. Or a lot of the times if Tegan feels like it's hard for her to talk to her mom or vice versa, I will sit with her and I don't want to say make her, but like sit with her so she feels a little more brave to discuss things that are bothering her with her mom. So that, like I said, 2023 it wasn't the best year for Tegan and her mother's relationship. I think her mom lost her job. She ended up moving to Round Rock, which put even more of a strain. When I think the first week that she moved to Round Rock, they had that really big hailstorm in Round Rock and it totaled her car. So she didn't have a car and didn't have a job. So her time with Tegan really struggled. A lot of the times she lived in South Austin. Um, and me just being honest, I'm not taking her to Round Rock, and I would tell her I'm not going to take her to Round Rock because you chose to move there. I will take her to your mom's to meet you, which is in South Austin on Manchac and Slaughter, or I'm sorry, it's on Manchac and Brody, like at the end of Brody. And I didn't feel like I was supposed to take her to Round Rock because her mom wanted to live in Round Rock. And now, if her mother was in danger at the house that she was at, I would have done what I could to help because I just believe that. Because there's been times that I've needed help and her mom has helped me, but I don't know why you would leave your mom's house and move to Round Rock when your kid's life is south. And maybe that's not for me to understand, but my stance on it, because I wasn't given a reason of anything, was I'm not going to drive her back and forth to Round Rock, but I will to your mom's in South Austin,
Okay,
where she currently lives now.
thank you, Mr. Leverett. You've submitted some evidence to this court. Is there anything in particular you would like the court to take notice of?
I would really like the court to take notice of the 2 calendars that I sent in, and also the STAR tests that Tegan took when I got her in March. Her STAR test is in May of 2023 versus the STAR test that she took after being with me from time, in her scores on her reading. Now her math, I will admit, didn't do much better, but I don't know if, I mean, we were in school, it wasn't as much reading. Math is a lot of reading now. And so Tegan didn't read well. So I don't think that she did very well in math for that reason. Math is not, in her age group, it's not, they want to know if you know how to get the answer, not what the answer is. They want to know if you can, and when she reads, the questions are very tricky. They, Jane has 10 apples, Marshall has 12 apples. How many apples does Carlos have? And it throws her off because she wasn't comprehending reading. So I do think that that's kind of where she struggled. And Tegan was in the middle of COVID as well. She moved with me during COVID because I was living in Pflugerville at the time, but my cousin, who we shared a house, she was a teacher. She graduated college the previous year to be a 3rd grade teacher. And so we found it better that Tegan moved with me to kind of help her education. And I don't think it was just Tegan. I think a lot of kids suffered that year, educationally, during that time because they weren't in a classroom environment.
Okay, sir, I'm gonna run some numbers by you. The cost of your health insurance, just for your daughter, is that $190, is that correct?
Yes, sir.
And Ms. Eden sends you $95 a month towards that, is that correct?
Yes, sir.
The current cost of your dental plan is $18.21 a month, is that correct?
Yes, sir.
Do you know how much a more comprehensive dental plan would cost?
Yes, sir. I'm going to pick up my phone just to look at the note that I have. I have it right here. The better dental plan is, the top option would be 411 and 411.14 a year which would break down, I think it breaks down to 30 something dollars. I'm going to say 35 to be safe dollars a month. For both of us. That would be, my half would be 35 and her half would be, no, I'm sorry. 411, let's do 412 divided. Yes, it would be half of $35 a month. So it'd be $17.50 a month for both of us. If we both paid half, it would be $17.50. And that's for the higher dental insurance. So I think it would add maybe $10 to her current insurance.
Okay, thank you, sir. Is there anything else you would like the court to know?
No, sir. I mean, I do. Yeah, actually, I, 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 I have Tegan in volleyball, and I pay every month for it. It's close to $300. It's about $280. I take her to all her practices. I buy all of her equipment. I do want to say that her mom did this year. She helped last year when she could. And she helped. She cannot help this year. I didn't know about the volleyball schedule. They're not very well at telling me the schedule until it happens. So I just ask that whatever happens, if she can continue playing volleyball because she does love volleyball, that's the main reason why I need help. Tegan is 10 years old. She's expensive. I don't ask her mom really for much of anything. I don't ask her for any sort of financial help except for extras. Tegan's volleyball, or say Tegan wants to get her ears pierced, or but shampoo, deodorant. I take care of all of that. And I don't have a problem doing it, but it gets a lot. It gets a lot after a while, especially when it's not appreciated or recognized, because I do a lot for Tegan. I take very good care of Tegan and have. So I just ask that really, I just really don't want her schedule to change. Because it would really affect Tegan. And I think if her mom says anything different, it's a disservice to Tegan. I don't think that her schedule would, I don't think that Tegan would do any better with Miss Seaton's proposed schedule. It would be an extreme change for Tegan of what she's used to in the last 2 years.
Okay, thank you, sir.
Yes, sir.
That's all from me, Your Honor. I'll pass the witness.
Let me ask real quick if I got this right, or maybe I missed it. From your perspective, have you ever done a 50-50 with Miss Seaton?
Yes, ma'am, we did when Tegan was younger. It was, I don't want to say it was 50-50. It was a little more loose than that. I feel like up until Tegan was a little bit older, that we were pretty, wherever Tegan went to school is kind of where Tegan lived, and that was her home base per se. And so yes, I have, but it's just like her mom lives close to a school that Tegan would go to. I live close to a school that Tegan would go to, and it's not feasible to wake up in the morning and drive. I mean, I'm in Kyle, but it's Austin's hard to get through in the morning. And it just, I think that waking up at Tegan's first bell rings at 7:30 in the morning. I think her mom would have to leave 45 minutes to an hour early to get there, and then at 7:30 drive another, hour and a half to her work, which I believe is on Congress, which is even more traffic going north on 35. So we tried 50-50 when Tegan was younger, but it just didn't, when she started school, it wasn't that way.
Okay.
It doesn't help Tegan.
So like when school started, what, at kinder or first or something?
Yes, ma'am. She started in kinder, and Miss Seaton was living with her father at the time, and that's where Tegan went to school. I can remember the day that I dropped Tegan off over there to go to school because I was super upset because I was losing a lot of time with my kid.
Okay, and then, well, I mean, she's 10 years old, y'all. I want to say must have done a pretty darn good job to wait 10 years to come to court to fight it out. But you can't work it out at this point on your own. That you've
I've
done
tried.
so well.
I believe that we've tried. I just believe that I believe we have differences, and I think it's sometimes hard for us to communicate to each other. I'm probably not the easiest to communicate with sometimes, and I'd probably say Nikki's not the easiest to, we're in different parts of our lives now.
Like, I think I'm not required to talk to the child if y'all ask me to, unless the child's at least 12 years old, but if the child were here and I talked to her without y'all in the room, what do you think she'd tell me about who she wants to live with or what she would want for her situation?
Uh, personally, I ask her, I don't want to say I ask her often, but I've asked her if she wants to live with her mom, and she tells me that she doesn't. I don't know if she tells her mom the same thing. Tegan gets frustrated with me because I am the disciplinary parent. So it's very well she may tell her mom that, my dad got onto me because Tegan has chores at my house. She's she can be a kid, but she has to read every day. She has to do things that a kid has to do every day.
Um, so I understand, and you told me that you have another child, so she has a sister there. Is that same case with mom? Does mom have other kids that are also, that would be siblings or have
No,
siblings?
I don't believe so. No, sir. No, ma'am. Sorry. No, ma'am.
And when this happened in February or March or whatever you told me of 2023, when this kind of flip was made, where you got more time than mom did, is that what I understood, right? Is that
Yes.
right? Then,
Yeah.
from mom's perspective, did she give you a reason, or do you know why she would have done that?
Why she would
You said
allow?
generally that it was hard, something happened. I don't know if anything specific
Keegan,
happened, but what?
Keegan had stated a few times that she wanted to live with me and that she wanted to live at my house. So we talked to her mom on the calendar. The exhibit that I wrote, she started asking me in like early January. It says on my notes the 29th of January if that she wants to live with me.
For 2023?
Yes, ma'am. And so me and her mom discussed it, and we found it better that she moved during spring break, so she kind of had a break and a chance to transition. And then from that point, I had Tegan a lot. I had Tegan the majority of the rest of the year. I mean,
Yeah.
from March 13th, I had her 223 nights. I mean,
Okay, did you have another part of an agreement that even if the child went to live with you, that mom would have a certain time period, or that you'd review it at a certain period of time, and that she wanted the child back or not, or?
no,
what was the
ma'am.
rest of it?
To be completely honest with you, I felt like everything, if I would have never filed with the AG's office, I don't even believe that any of this would be an issue. As soon as I filed for the AG's office, because when she moved, it scared me because I remember my mom being able to leave. So when she moved to Round Rock, we didn't have an agreement in order. And honestly, it did. It scared me because I didn't want her to be able to move my daughter. And I know that without an agreement in order, there's not really much that I can do if she were to leave. So that was the reason of me file. I couldn't afford an attorney to do it. So I did my research and found that this was the best route for me financially to take, to where it didn't change our lifestyle or the kids' lifestyle or anything. But I don't believe that anything would be different if I never would have filed. I think that I don't see there any reason why somebody would disagree that Tegan's done a lot better with me. I mean, if she's at her mom's and doesn't do what she's supposed to do, her mom calls me. So
Okay, but I guess I'm trying to figure out, there was no agreement that from your perspective that I'll have the child for 6 months, you get her back at the beginning of school next year, or anything specific like that?
we had to said we'll discuss it. Hey, it's just for a year. We'll discuss it at the next year at the school year. And it was not. I don't. To my knowledge, I don't remember if we discussed it. If it was something that was discussed, we were kind of going through the motions, and I signed Tegan up for school. I just figured that's what we were doing.
Okay, let me do something real quick.
Yes, ma'am.
Okay. Then, okay, so March of last year, you finished the school year. The start of the next school year would have been August. You
Yes, ma'am.
didn't discuss it?
No, ma'am. Not to my knowledge. I don't remember us having a conversation. I think it was just
Okay,
Tegan
so
wants
she
to live
went,
here.
so the child's in school where you live. And so
Yes.
this next school year, this school year that just started last month,
Yes, ma'am.
you didn't have a discussion at the beginning of this school year?
We had a little bit of a discussion, but that was because Miss Seaton was served with the papers, and it kind of got a little, like I stated last time we were here, it kind of got a little catty between me and her about what the schedule was going to be, and we came to the agreement of I don't wouldn't say that it wasn't, maybe we came to the agreement, but we just kept the schedule. I think that her mom maybe heeded your advice that you gave last time of don't change up her schedule, because that was literally Tegan had been in school like 2 days of I believe I don't remember when the first, or it was, she was going to start the next day or something. She had been in school maybe 2 days or was fixing to start school the next day or two.
Okay. Okay, then let's move on now. Ms. Joseph, next witness.
Your Honor, I believe we need to give Ms. Seaton an opportunity to. Ask
I
questions.
do usually do that, but after I hear both sides and then they've heard everybody's
Okay.
testimony, and then we do the cross-exam.
Okay.
That's my preference, so.
Okay.
let's get to it.
Thank you, Your
Okay.
Honor. Ms. Seaton, could you please state your name?
Nikki Nicole Seaton,
Could you please state the name of your child?
Tegan Elizabeth Leverett,
And who is the father of your child?
Marshall Lee Leverett.
And what's your relationship like with him?
I think it's pretty good. I agree with what he said. We most of the time we can communicate about things, but there are some things that we just don't agree on, and so sometimes, yeah, communication is a little bit off, but for the most part, I think things are good.
Okay. It's my understanding that irrespective of the custodial determination that you agree to a joint managing conservatorship, is that correct?
Yes,
If you are named the non-custodial, I'm sorry, ma'am, if you're named the custodial parent, would you agree to a geographic restriction requiring you to live in Travis County and all the counties, or any of the counties surrounding Travis County?
yes.
Okay. I've submitted your proposed visitation schedule for the court's review. Before I get into that, what's your living situation like, ma'am?
So I live in a house with my mom and my stepdad, so that's Tegan's grandparents, and then my partner.
And how has visitation been going?
I think it's been going well. We try to keep it consistent, and then, yeah, I didn't want to try to change her schedule from our last reset hearing till now, so I've kind of just let things be how they have been. But yeah, things have been going well.
And what's your daughter's relationship like with her grandparents?
She loves them. She loves my mom. We all do things together all the time. We watch movies, play games, she's very close with my mom. They're a little funny with each other, but they love each other very much.
Now, I want to direct your attention to the proposed visitation schedule you've submitted to us. I've submitted it for the court's review. Why do you believe this schedule is in the best interest of your daughter?
I actually haven't had a chance to pull up the screen to block my Zoom and look at it myself. So why don't you let her explain it a little bit, Mr. Asif, for my benefit?
Yes. Please explain it, and then please explain why you feel it's in your daughter's best interest.
Okay, so currently I've proposed either a week on, a week off schedule, and we usually, when we were doing that before, we agreed on the day that it would be. I think we did it during the summer at volleyball practice just because we were both there. Like, it was easier for us to switch, or a 2-2-3 schedule, which is kind of the same thing. But I feel like this both allows us to have equal parenting time, and as well as being equally involved in her schoolwork, her activities, her projects, things of that nature. Prior we did, whenever she did move with Marshall, we did try the week on, a week off, but she was having issues with the change. And I don't just think it was the change of, the timing. I 100% believe part of that was because she had been with me most of the time, and then it was her not with me at all, hardly. And that's a big, emotional change for her. So she kind of did have a little bit issues with that. The main reason we did agree to move her to the school by his house was because she was really struggling with her ADHD at the school by my house. Her 504, the program wasn't as extensive as it is at the school that she is with by Marshall's. I do think that they do a lot better job at trying to help her manage her ADHD and really try to, help her with her schoolwork in that sense. So that was the main reason why we decided to move her to that school by his house, because yeah, she was struggling with that a lot. And during that time, it was right after COVID, so she was struggling with reading. It was a big struggle at that school. So we decided to move her to the school by his house to see if it was better. And I do agree that it has been. And then, sorry, I'm losing my voice. And during that time as well, we were trying to figure out evaluation for getting her, they had told us that she needed some kind of brain scan to get medicated for her ADHD. So that's why it's been so long, but we were able to find another resource, get her evaluated, get her on meds. So hopefully this year we'll see, the results of that. But I think that was one of the main reasons why she struggled in school with reading so much. And then that was why me and Marshall hired a reading tutor to help get her back to where she needed to be. And so I think, the test results that Marshall sent in reflect that, as well as, us helping her at home.
Thank you, ma'am.
But I believe it's in her best interest just because we were doing that prior. Yeah, for the last year, it's been a little different, but 7 months of that was because I had no job and I had no car. I do believe that if my life would have been, came out a little bit different, we could have done that and it would have been fine. But that 4 months, because yeah, she changed in March and then I was laid off at the very beginning of August. So that month in between, I was working a lot because I was actually supposed to get a promotion at that job. And then unfortunately they went bankrupt and that's why I was laid off. So there was a reasoning behind me working more. I was trying to, make a better salary to be able to give Tegan a better life. But just the circumstances unfolded the way they did, unfortunately. And so, yeah, I ended up losing my unemployment or my employment. And then I also lost my vehicle. So that made it harder for me to see her consistently. And, just financially, it was a strain. But now I have been working, I've caught up on everything. I'm able to see her, I have a vehicle, my life's back in order. And so that's also another reason why I believe the week on, week off will work is because her school is only 15 minutes from my house. That's more, even with traffic, it's 20 minutes or so. I can do that easily, take her to school in the morning, get her there on time and go to work after. It's not a problem. I don't have any issues getting her to her volleyball or anything like that. And she has expressed to me multiple times that she does want to be with me more and she does want me to be able to take her to school and do these things.
Okay. How have the recent visits been going?
I think they've been going well. We really do try to get her creative side going. I'm a creative mind myself. So more recently, we've been doing a lot more arts and crafts. My partner is very into health and wellness. He's a marathon runner, so he's been trying to train her with running. We've been getting her into like lifting weights a little bit, just trying to, get some of that energy she has from her ADHD out, but also helps with her mental health as well. So I think they've been going really well.
And does your partner, do they live with you?
Yes, he lives with us.
With your mother and your stepfather?
Yes, we share a house.
And what's your daughter's relationship like with your partner?
I've only been with him for a little over a year, so they're just now getting to where like they're able to like, really communicate with each other and find common ground. She likes him, he loves her. There's no issues there. They don't really spend a lot of time alone, but when we are together, like I said, we're working out or we go on a hike or we do activities together to kind of help bond them on things that they like.
Okay. Now, I want to get your side of the story with respect to what happened in 2023. From your perspective, what was the reason for your move to Round Rock?
So my partner is from Dallas and he was moving in closer this way. His living situation was a little like he needed to move fast. And so he was able to get into an apartment there at Round Rock. We were going to live together and find a house down south, but it was just timing wise. And then right after we signed the lease, I lost my job. So even with the drive to Round Rock, it was only like 30, maybe 45 minutes to where, her school is now, which wasn't a problem for me. But then, like I said, circumstances, I lost my job and then I lost my car. So that kind of made it impossible for me to consistently be able to get her to school and get her to where she needs to go and what she's doing.
Thank you, ma'am. And what was the reasons for your subsequent move to South Austin, I believe it was?
So we decided to move out of that apartment complex because there's just a lot of like weird activity going on there and we didn't feel safe. So we decided to move back down south. And then just also sharing a house financially is just a little bit easier. And then we also have a German Shepherd, so having a yard for her and for Tegan. And then also with her being in volleyball, I just think it's easier on me as well. Just, between work and volleyball and all these other things going on, it's just a little bit easier to be down there.
Okay. You are sending Mr. Leverett $95 towards health insurance, is that correct?
Correct.
Have you sent him any other, anything else for the welfare of your daughter?
So I continue to, try to split everything 50-50 with him. I sent him half for her school supplies. We agreed that, I buy her clothes and shoes for my house. He buys her clothes and shoes for her house. That's how we've always kind of done it. There have been times where we did split her school clothes and stuff like that. And then I'm sorry, what was the question again?
Oh, if you've sent him, other than
yeah,
the
and then-
$95 a month, if you've sent him anything else for your daughter?
Yeah, and then so I split her volleyball with him. I've paid for half of her school computer. I tried when I was unemployed to send him money for her school lunch account. Though I sent him money for every single month for her volleyball and whatever I could every month while I was unemployed as well. And I have all those receipts that I sent in to show you that. So I've always tried to help him like with whatever I can and then provide her like he does at his house, with her toiletries, haircuts, whatever it is at my house, I provide just like he does at his house, food and whatnot.
Okay, ma'am, I'm going to run some monetary figures by you. My understanding is the cost of your health insurance for your daughter is $91.74. Is that correct?
Correct.
And the cost of the dental plan, that's $46.38. Is that correct?
Correct.
Are there more comprehensive plans available to you?
I believe so.
Do you know how much they would cost?
I don't, or actually, I think that is like the highest dental.
Okay. With respect to the medical insurance, then the medical plan, do you know how much a more comprehensive plan would cost?
That's the only one that we have.
That's the only one. Okay,
Mhm.
thank you, ma'am. Are you employed?
Yes.
What do you do for work?
I'm a workplace coordinator for Vital Farms.
And how much do you make?
I'm on a bi-weekly schedule, not a salary. So monthly I make about 4,000.
Okay. Are you in agreement for the current situation where your daughter will remain on Mr. Leverett's health insurance, on your dental insurance, and you would continue to send him the $95 a month? Are you in agreement for that to continue?
Yes.
Thank you, ma'am. Now, I just want to be sure I understand you right. You are requesting child support if awarded, if the court declares you to be the custodial parent, you're only requesting child support if there is not a 50-50 split. Am I understanding you correctly?
Correct.
Okay. I've calculated guideline child support. If you were named the custodial parent to be $895 a month, with payments to be on the 1st of October. Do you have any objection to that figure?
No.
It's my understanding you're waiving retroactive support. Is that correct?
Correct.
It's my understanding you are not seeking non-disclosure of contact information. Is that correct?
Correct.
So you believe Mr. Leverett is not a danger to you or your daughter?
No, I don't believe so.
Thank you, ma'am. Okay. You've submitted, do you have any other children?
No.
You've submitted some evidence to the court. Is there anything that you would like us, the court to take notice of?
Let me see. I sent in the receipts and then the plan, correct?
Receipt for the what?
I sent in some receipts just to prove that, I've been trying to financially help, even when I was unemployed. And then we sent in our parenting plans, correct?
Yes, I've provided that to the court.
Okay, awesome. So yeah, just taking note of those, like, because I provided 2 different schedules. So I'd be happy with either one of those. But I also think that it would work, in my opinion, I think it would work better for her if we did week on, a week off, instead of switching on the 2-2-3, like in the middle of the week.
Okay, Ms. Seaton, you've requested that this court name you as the custodial parent. Is that correct?
Correct.
Could you please explain why do you feel it's in your daughter's best interest for you to be the custodial parent?
I feel it's in her best interest just because I was never legally, I guess, named custodial parent, but back in 2017, we did have a family mediated agreement to where that's where we agreed to joint managing conservatorship, and a lot of the things that we're agreeing to now. But Tegan has been with me most of her life up until COVID hit, whenever we did agree that she would go stay with him while she was in school. Because COVID, it was iffy of like, the school was open, then it was closed, then it was open and it was closed. And since his cousin was a teacher, we thought it would be best for her to be in, one place, being able to go to school during COVID. Now, after that, she did come back with me, and then that's when we moved to South Austin and we enrolled her in the school by my house. And then after that is when, she kind of went with him. So I feel it's in her best interest just because she has been with me her whole life. And yes, she did have a hard change going with him. Now that she's with him, it's easy because she's been with him. But she does express to me all the time how much she misses me, how much she wants to be with me. And, I know it's hard for her. We both came from divorced families. So I don't think it would be in her best interest to be with me, full time, or be with him full time. I think for her emotionally and just for stability wise, I believe it's in her best interest to be with both of us 50-50. That's when she seems the most happiest. That's when she seems like everything's just calm for her. And yes, she has ADHD, and routine is, good for her. But when it comes to discipline, Marshall stated, when she gets in trouble, I have to call him. Yes, there are times where I have to bring in the dad authority, because we all know that kids, feel a little bit more scared of their dads than they do with their moms. But for the most part, I think she does have an understanding of how I work and how he works, and she does try to kind of use that a little bit. But I think now that we have we're getting her ADHD a little more under control, and she's getting older, that she's kind of stabling out those things.
Thank you, ma'am. Forgive me if I'm repeating myself. I may have asked you this already, but how much do you make?
$4,000 a month.
4,000, and that's before tax, correct?
Yes.
Thank you, ma'am. Is there anything else that you would like the court to know?
I think we've gone over everything. I just do want to note that I don't want it to seem like, that I'm not financially trying to help, especially like with the volleyball thing, because I know I did agree that I would help pay for volleyball. And I did. And then up until I told him this year that I wouldn't be able to, just because I know she's going to have braces. So that adds on to our monthly. And then us hiring her a math tutor, which I feel those 2 things are more important to put in front of volleyball, which yes, I know volleyball, she loves it, but I feel, those funds have to be allocated to her medical needs first.
Thank you, ma'am. I have no further questions, Your Honor. I'll pass the witness.
Let me double check to make sure I understood. So you would rather have the medical insurance on you now instead of paying him the $95, even though you're paying close to 92, I guess? And that would be
No,
Yeah.
I always just agreed that whosever plan is better, that we would just split it. I've just always asked to split everything.
So if he wanted to keep his and you continue the 95 to him, is that what?
Yeah,
you're
that's
saying
fine.
is okay? And I
Mhm.
think that's what he said.
Yes,
That
ma'am.
he carries, yeah. And then on the dental, I think he said he could get his higher plan and then just split the difference of 1750, but you're saying not, or that you want to keep your dental? Is that what I heard?
Yeah, I'm fine with her staying on my dental.
But have you compared the two plans? If he's, so you're the one that already has dental, he's the one that's trying to get dental under the open enrollment? Or
No,
under
I
the
don't
court
believe
order?
so.
I'm sorry.
I-
Go ahead and explain it, Mr. Leverett.
I have her on dental. Her mom just
Okay.
has her. The
Okay.
plan of dental that I don't have her on doesn't cover $1,000 of her braces. The plan her mom has on does cover that 1,000, but I can get my dental switched with a court order to the higher dental plan, which I think covers $1,500 of her braces versus the 1,000.
Okay, so
It was a
you'd be only to
secondary.
get it the higher level and then, but you're saying at the higher level, all you'd be asking her is for 1750 of that.
Just half of whatever it is. Yes, ma'am. And I believe that's half. She has that information as
Okay.
well.
Mm.
And yours, if his plan is better with the higher, or whatever that is, at 1,500 instead of 1,000 and only 1,750 instead of $46, you wouldn't be willing to switch to that, Ms. Seaton?
Yeah, that's fine with me. Just whatever is
Cheaper
gonna
and-
help. Yeah, cover her braces.
It might be easier to have medical and dental with the same parent and have however that works with the insurance, whether the same company that provides different things. And it's a little cheaper, so you're okay with that then?
Yes, ma'am.
He keeps the medical and you still pay him the 95, and then he raises the levels on the dental, but keeps the dental. And with a court order, he can bypass open enrollment and then only pay him 1,750 and you can drop yours for her on the dental. Okay, I get that. That's not an issue anymore then. Okay, has anybody looked at the current standard possession order with all the flips it has, including Thursdays through Monday mornings and all that holiday time? And then we could even tweak the summers, as Mr. Leverett said, or was considering. So Ms. Seaton, have you looked at that, and why would that not just be better?
So yes, ma'am. Currently, that's what's on our mediated agreement that we both signed, is that Marshall is on the extended standard. So he would have her first, third, and fifth weekends beginning on Wednesday, and then every other, and then drop her off Sunday, and then every Thursday. But the reason why we had it split like that is because she was going to UT Child Development Center. So I would drop her off and then he would pick her up from school. It was just easier because he was working in Austin. And I was living in Elgin at the time. So that's currently what we had in place.
But for
that-
him,
But that order is not,
no,
order got thrown
don't
out.
interrupt. I got it, Mr. Leverett, hold on. When you said you had a mediated agreement, that means something legally, but I'm not sure you went the legal route. Did you go to some kind of dispute resolution center, or you just sat down with?
Yes, ma'am. This is what it says right here.
Who's it from? You read it from me, dispute resolution. Okay. However, just
Yes.
because you went there, does that mean, did you file a lawsuit with it? Did a court sign it? Anything like that?
It just states that we both signed it, our mediator signed it, our lawyers, and then it says this agreement is not subject to revocation.
Does it say it's filed with a court and a court approved it?
Not on this copy that I have.
Well, you get that you didn't stick with the agreement if you flip possession. And
Right, so during this time, we also agreed that if we can come to an agreement outside of this paperwork, that's what we would do, but if not, then we have to go back to this agreement. So we did agree to that.
Just take any position on the legality of all that, or have you even reviewed it or know about it, Mr. Asif?
I was informed of the existence of the agreement. I don't have state doesn't have a position, on the legality of it one way or the other. But I was made aware of the existence of the agreement, yes.
Okay. Have you seen the current standard possession order that it's not just Friday to Sunday, it's actually Thursday to Sunday, and then every, what is it? Help me, Mr. Asif, the current one with the extra longer weekends.
Yes, Your Honor. My understanding is, the possession, the precise terms would vary depending on the distance between, the parties. I believe if it is less than 50 miles or between 50 and 150 miles, there would be, my understanding was it would go from Thursday to Sunday. Like one parent,
To
one
Monday
party would be in
morning.
possession from Monday to Wednesday. And then the other would, I believe, Thursday to Sunday with drop-offs and drop-ons occurring on Thursday and Sunday. The
Isn't it
rotation
from
of
Thursday to
flipping.
Monday, the under 50?
My
Under
understanding,
50.
Your Honor, is it's Monday to Thursday, and then Thursday is the date on which the exchange occurs.
Correct.
And then it would be
Yeah.
Thursday to Sunday, and then the exchange would occur again on Sunday.
It's not Monday, it was longer.
Or, oh, no, you're right, Your Honor. I'm sorry, Your Honor, you're correct.
Thank you, don't
I
mess
was
with.
confused.
I read these, but I don't read these because they're just standard and we just put them in most of our orders. However, right now it escapes the exact details, but then every second and fourth, not the first, third and fifth, doesn't she get an extra night or the other person gets an extra night?
I'm not certain, Your Honor. I don't have the exact schedule memorized, but
Yeah, I don't have a copy of the standard and available.
I can pull a copy and send it to you if you'd like.
No, that's fine. Why, let me determine that. Ms. Seaton, you said that, or I heard the stuff about living in Round Rock, but you're saying you're not living in Round Rock anymore?
No, ma'am. I live in South Austin, so
And how long
it's
has that been? How long
um
has you been there in South Austin again from your move from Round Rock?
oh, it's been about, let's see, about 6 months.
Did
And
Mr.
prior to that, we were
Leverett
there.
not be aware of that? Because he's telling me he doesn't want you to drive through downtown Austin in the middle of taking the child to school.
No, I'm completely aware that she moved out of that house and then moved back in, but she's also saying it's 15 minutes. You search it on the GPS, it's 30 minutes. From Round Rock, it's an hour drive.
Okay,
So I don't
thank you, ma'am.
know where we're getting these
I just
times.
wanted to clarify that because I thought you said that was a big deal right now that she's there now, so maybe I misheard. So you're not there now, and so he's saying it's some other amount, not 15 minutes to the school, Miss Eaton. Can you address that?
Right. I've been tracking it every morning and we would leave my house at like 6:45, between 6:45 and 6:50, and I can get her to school at 7:10, 7:15. Her bell rings at 7:25. The school is not 30 minutes from my house.
And
24 minutes right now in the middle of the day.
It's in the middle of the day though, not at 6:30 in the morning.
There's more traffic and okay.
There's more traffic during the day. We both live in Austin, Marshall. You know how traffic is here.
okay,
not-
you can stop talking to each other. You're talking to me, Miss Eaton. Stop, Mr. Leverett, interrupting. I'm not gonna be harsh about that, but I need you to stop. So if you want to be closer to the child and closer to the school and closer to the activities, and that's the activity she has right now, you're not suggesting that she be pulled out of the school and out of the volleyball and you get to pick somewhere else and maybe move to North Austin, North
No.
County.
No, ma'am. That was one reason why we never had like a true discussion about her starting school this year. I know she's made friends here. I know she likes her school here. And like I said, I know the 504 is better and her teacher, she has the same teacher that she had last year. And so she kind of knows all her ADHD things. And I don't want to pull her out of school. I do want her to stay there. I'm not trying to move. I'm not trying to pull her away from anyone. I'm not trying to do anything like that. I just want to have my daughter again. I don't believe it's best for her to only see me every other weekend. I hate it. She hates it. It just, yeah. And if
Would it
anything,
be
I do
fair to
have
take
kids.
her, well, to have her every weekend yourself so that then he doesn't have her every weekend or every other weekend?
Right. So I'm proposing, that's why I was proposing the week on, a week off, because then we have her the week during school and a weekend, and then he has her a week and a weekend, which is what we did before. And then that also allows both of us to be able to be involved in her school work, her school projects, etc. Because while I was unemployed, you know, Marshall and his fiance were taking a bigger responsibility in making sure that she does her homework and have her, school stuff done because I wasn't able to, I didn't have a car. It's not because I didn't want to, it's just my circumstances were unfortunate.
Can I please say something, Your Honor? Please?
No, I'm not gonna let you because she didn't do that to you. You just gotta wait. And I'm almost done with her, Mr. Leverett. And you distracted me now. I forgot my train of thought.
I'm sorry.
Okay, the geographic restriction, why would you agree or want to move any further away than where you are now? What, I'm trying to, even if whatever I do with the rest of it, if she's at the school she's at and she's got the activities she's got and the friends she's got and you're in South Austin anyway, with the exception of where you are now, if you moved, why shouldn't it be a restriction to Hays County and contiguous counties so you get closer, not anywhere near further away?
Yes, ma'am. So we have made plans to move closer that way anyways, just because Austin's super expensive and it's cheaper to live out that way. So we do have plans in the future to move closer. And then again, I don't want to pull her out of school where all her friends and stuff are. So just to make it easier on everyone, we have decided to move closer.
So if the geographic restriction for both of you was Hays County and contiguous, it still includes Travis. I assume you're not going to go to North Travis or go to Williamson. If we're
No,
around,
ma'am.
like this, then you'd go closer to where the child is. So
Correct.
if it weren't Travis County and contiguous, it was Hays County and contiguous, you would not have an objection to that?
Yes, I'm fine with that.
Okay, thank you. You have your hand up, Mr. Osteef. Is there something I need to consider?
Yes, Your Honor. It's come to my attention regarding the MSA. There's some ambiguity in terms with respect to its enforceability. I'd like to call for just a brief recess so I can just check with the parties and check with other AAG staff. I'm not certain we have the authority to do an order if the terms of the MSA are indeed in place. I apologize for that, Your Honor. I should have.
And this is like an hour and
that should have been
15
the first
minutes
thing I
later. I shouldn't be hearing this.
I apologize, Your Honor.
Well, I
should
just
have.
found out about it, or I would have stopped it earlier myself. Let me do this in fairness. Mr. Leverett, go ahead and tell me what you wanted to say 5 minutes ago.
She could be involved in anything that she wants to be in. Tegan comes home every single day and reads for an hour. Her mother, I pay for Tegan's cell phone. She has an iPhone. She could FaceTime her mom. My fiance sits on this couch every day and reads the same exact book that Tegan reads to help her read and help her understand. There's no reason why her mother could not do the same thing. So her saying that she could be more involved with school or she can be more involved in any of that, she could do all of that without any of this being in order or anything like that. She has chosen not to. The tutor that was hired, I hired the tutor. The 504 stuff that's at this school, I asked her teacher about all that. I signed her up for T-Chat. I did all of those things. It wasn't she found out about it and we found there's just a lot of things that I don't really agree with that are being said that are not true to make it seem like everything that we do is 50-50. It's not.
Okay, Mr. Leverett, I don't want you, it's still early here, to leave this courtroom worse than you started off. Y'all started fairly amicable. You're saying great things about each other as parents and co-parenting, and that you've gotten along for 10 years without the courts. However, now you have a difference of opinion. Now she's older. Now we got to do something. Maybe. Now I just heard for the first time about the mediated settlement agreement not that long ago.
Can I say something after that? I hired an attorney. It was never filed in court. It was thrown out in court. That agreement was filed in Bastrop County. He'll find it. It was the attorney that I was going to hire looked it up. It's non-existent. It's in the eyes of the law, it is non-existent. It wasn't filed. It was thrown out in, I think, March of 2020 or 2019 or something like that.
What do you mean by thrown out? I don't understand.
It was not filed. It was completely dismissed. It was not. It
was not filed. It couldn't have been on file and been dismissed. So what do you mean?
Maybe I'm not too familiar with the law, but the attorney that I spoke with told me that it's not. It's fugate. It's in the air. that's not an
There's
order.
also provisions that says it's irrevocable, and there's certain law on that, and I'm not even sure what that is because I don't deal with mediated settlement agreement. So let me ask this, well, let me do this. Do you have any questions of Ms. Seaton, Mr. Leverett? Any cross-examination, the right of cross-examination before I stop this? And I have another case.
Your Honor, we don't, actually, I think we can, the issue of the recess, I don't think a recess is necessary. I've conferred with, some other AAG staff, and it's come to our attention that regarding the MSA, we looked up the case in Bastrop. It was, cause number 4234904. And it looks like the MSA was actually never reduced to an order. There's actually a dismissal order on it dated December 20th, 2021. So it was filed, but it was dismissed. So we can carry on.
So what does that mean, that there's no effective and medical MSA, that mediated settlement agreement?
Yeah,
that-
it's the state's understanding that the provisions of the order are not presently in effect. It was dismissed.
Are you aware of all that, Ms. Seaton? It was
No,
filed.
I
and
wasn't.
dismissed? Who
I
filed it?
was not.
How did it get to court then, Mr. Leverett? Do you have any idea?
I do not, ma'am. I had no idea about this until this started and I was going to hire this attorney and they looked it up. That's,
You didn't file it, Ms. Seaton? It doesn't magically show up at Bastrop County and.
It had to have been filed by one of our lawyers, because when we did it, we both had lawyers present, and they said, once we signed it, the mediator signed it, that it would be filed. And then that was the last thing I heard. I didn't know that it was dismissed or anything like that.
And if it was dismissed, then it's no longer a valid agreement between you all. So the terms of it can't be enforced by the courts if it's not a court order.
Your Honor, if it helps, I was able to dig up the dismissal order. I can send it to you if you'd like.
Well, I'd be happy to look at it, but I'll need to take a break pretty soon and hear something else. But anything else? Did you have any cross-examination questions of Mr. Leverett, Ms. Seaton? You have
No,
anything
ma'am.
to ask him, Ms. Seaton?
No, ma'am.
Okay, did you bring any witnesses, Mr. Leverett?
no, ma'am.
Did you bring any witnesses, Ms. Seaton?
No, ma'am.
The state have any other witnesses or evidence to present?
No, Your Honor.
Okay.
Although, the only thing I want to say is if the court wants, we can forward a copy of the dismissal order. Regarding
I did want to see it real quick. I do want to see it.
Yes, Your Honor, I'll get that to you.
I'm actually on Zoom and I can still hear you all. I won't be able to see you. I'm going to put some other screens in front that I'll be looking at, so it might look funny, but I have no way of doing it otherwise.
May I get a glass of water? Can I get out of the frame or no?
No, I'm going to finish. I got to get going. I can't wait on you to get water, mister. Let me find my email that I'm going to look at. Have you sent it already, Mr. Osif?
Yeah, yes, Your Honor, I'm doing it. I'm just having, we're pulling it right now, Your Honor. I apologize for the confusion.
Yeah, it usually takes about, well, you haven't even sent it yet?
No, Your Honor. We found the dismissal, we found the order. It's just a matter of downloading and emailing it.
Do you
I
want to read it
apologize.
to me? Just read it to me then. Is it more than a page or a paragraph?
Well, I don't have it in front of me right now. One of my colleagues is in the process of getting it to me.
Okay.
Okay, Your Honor, what we could do is, it may take some time to pull the order. If you'd like, we can recess and recall once we get it.
Do you have any idea what's waiting on me for the next case? Is it short or long matter?
I'm not certain that there's a few defaults. I think there's a defaults waiting, as well as a two-party
Then I'd rather finish this case instead of holding these people hostage before I start something else.
Okay. All right. My colleagues are in the midst of getting it to me.
Okay.
We do have a default waiting, but. Your Honor, yeah, there's some accessibility issues. Unfortunately, the only staff that we have that can access the Bastrop County register, they're both on their lunch break right now. We will need at least 30 minutes to pull the order. That being said, we can tell from the public court file website that there is a dismissal order. I'm just not able to pull it, but I can confirm that there is a dismissal order that does exist for this MSA. So if you'd like, yeah, we could either recess or reapproach, or
Yeah, okay, it's
we
a
could
big
carry
deal
on.
having this mediated settlement agreement and whether it was filed or no longer on file, if it was dismissed and what the dismissal order says. So in abundance of caution, I'm gonna go ahead and wait till we get a copy of that. So right now I'm gonna stop the case so I can start some other ones and probably in about 30, 45 minutes, try to get back here to resolve this matter. But I
Okay.
think it would be in my interest, everybody's interest, especially if this could be appealed, that I get the mechanics of the MSA right instead of guessing or assuming. I'm not gonna do that.
Yes,
If
ma'am.
it's available to us. Okay, so then I'm gonna put you on hold. Well, tell you you can remain here or put you in a waiting room. I think that'd be the best thing to do here.
Yeah, yeah. We
And
can do that.
then stop my recordings and then start something else or a couple of quick things and come back when you tell me you're ready, Mr. Asif.
Okay, I apologize, Your Honor.
Apologizing, I just need to get done.
Yes, Your Honor. Sorry about that.
Okay, go ahead and let's see here. I must have to stop my recording and start them all over again because there's no way to do it otherwise. So I'm gonna stop my digital recorder and stop the live stream fairly simultaneously. And we'll be back when the state's ready with that dismissal order.
Yes, Your Honor.
Don't check out. I'm gonna try to get you put into a waiting room so you'll have somewhere to stay instead of my courtroom so I can use it for other business. And then we'll bring you back in. If something happens, you get knocked out of the Zoom or dropped off or you run out of battery or something happens, make sure you get back here as quickly as possible to this meeting room. So you have that number written down. You can get back in here if something went wrong. Okay.
Yeah.
We're going to just say, do we know how many days she's been incarcerated?
55 today, sir.
Okay, so we're gonna do 50 days at OCJ and we're stipulating that credit for all time served has been served and that probation will terminate upon release from the jail. But
Okay.
there should be nothing in this case that's holding her. She should be free to go to Oklahoma, back to Oklahoma.
And there's a $100 cost of prosecution.
That's correct, Your Honor.
Okay. Any other outstanding financials probation for Ms. Campos?
I
paid all my court costs.
It's like a court cost. When there's a VOP, they have a separate charge of
Okay.
$100.
Gotcha. Okay.
I'm sorry, Your Honor, the computer's not working.
Okay, that's fine. Ms. Campos, if you'll raise your right hand, do you swear to tell the truth, the whole truth, and nothing but the truth so help you God?
Yes, sir.
Thank you, ma'am. You can put your hand down. Ms. Campos, so do you understand that if I accept your plea, that you're waiving your right? This was a VOP, correct?
That's correct, Your Honor.
Okay. That you're waiving your right to an evidentiary hearing where the state would have to prove the violation of probation against you?
Yes, sir.
Okay. Do you understand, and that's good that the state changed that from guilty to withhold? Yes, ma'am, probation. Okay. So, Ms. Campos, I don't see any other downside other than the $100 cost of prosecution. How long will it take you to pay that?
I could pay it the moment I get out, sir.
Okay, how about if we say within 30 days?
Yes, sir.
Okay. So, Ms. Campos, I do accept your plea. Adjudication is withheld. You're sentenced to 50 days in the Okaloosa County Jail with credit for all time served, and the state stipulates that you've already served that amount of time. You'll need to pay the $100 cost of prosecution. If you fail to pay that within 30 days from today, it will go to a civil lien or judgment. Okay?
Yes, sir.
Thank you, ma'am. Good luck to you.
So
Yes, ma'am. And her supervision is terminated.
it's terminated after she gets released. So is it technically
It's
reinstated and modified and then on?
No, we just want to terminate now, whatever we need to do to accomplish that now. Because she's already, we sentenced her to 50 days and we're stipulating that she's already served that. And that was the only condition of probation, so it should be able to terminate now.
Your supervision is terminated today.
Okay.
Okay,
Yes, sir.
And Your Honor, being that she's no longer being supervised, the $100 would be payable to the clerk.
Yes, sir. Okay. Thank you, ma'am.
Thank you, Your Honor.
Thank you, Mr. Switek.
I appreciate it.
Good one.
Okay, thank you.
She's also on the 130 docket.
Thank you.
However, no information.
Thank you, sir.
Okay.
Yes.
Good morning, Ms. Starks. Yes, Judge, this is Ms. Starks to my left. Your Honor, if we could put this on the afternoon, to roll it to the afternoon, I want to talk with Mr. Snell. No information has been filed on the new case, but she does have 4 VOPs that are close to resolving. If we can put it to the afternoon.
Okay. Mr. Gomez, why haven't information's been filed in these various cases?
Which ones, Your Honor? I'm sorry.
Rainey, Rodriguez, Stafford, Starks. Start with Starks.
I can't answer that. I'm not the ASA that's on that case, Your Honor.
Okay, if you'll rattle some cages and tell them that the court's concerned about so many or not, because it's my understanding that there were also 1, 2, 3, 4 that were just filed like yesterday or today. Okay.
Yes, Your Honor.
So do you want Ms. Starks back at 1:30 or at 2:30?
I believe Mr. Snell is coming back.
You should be, yes.
The 1:30, Judge. I'm going to talk to her on the lunch break.
Okay.
Your Honor, can you state those names again? And what I'm going to do is I'm going to go back and make sure that they get filed so that we have a hard copy when those defendants show up to plea day.
Okay.
Today.
Okay. Ms. Starks, I'll see you this afternoon.
Okay.
You take that with you.
As far as the ones that were just very recently filed, McNamara, Oglesby, Rice, and Sawyer.
Was Rice filed?
Yes, this morning, like 45 minutes ago.
Okay. Are there still ones that we do not have an info on?
Correct.
Which ones are those?
Rainey,
Okay.
Rodriguez,
Okay.
Stafford, and Starks.
Stafford and who else? I'm sorry. Your Honor?
Starks. Ms. Starks.
Okay. I will make sure to get those filed before we show back up this afternoon.
Okay.
Or I will make sure somebody gets
Good.
it filed.
Thank you. Okay. Rachel, who's next? Hello, Mr. Rudolph.
Your Honor, this is Mr. Rudolph in 22 CF 2613. If we can also put Mr. Rudolph at the 1:30 docket, so I can talk to Mr. Snell for possible offer to get a release today.
Okay. Mr. Rudolph, I'll see you at 1:30, okay?
Yes, sir.
Thank you.
Adrian Rico Garcia.
Thank you.
Good morning.
Good morning, sir.
Good morning. Judge, this is Mr. Garcia in 22 CF 2966. If I can get a date in May with subs.
Okay.
And of course, I just want to, if with permission from the court, if we do reach an agreement, I believe those Thursday dates that were also present here, we could also enter a plea.
Yes, sir. So, Mr. Rico Garcia, what your attorney's asking for, from the court's perspective, is get a backstop on this. Let's get an end to it. You know, your face is always, I mean, you're always very pleasant when you come in, but we got to get an end to your case. And so I'll set it for May 16th at 2:30. So that's for basically the judge trial. If it's not resolved before May 16th at 2:30, and everybody will put on their evidence, and then I'll determine whether there's a violation. And then we'll talk about sentencing. So, but What also Mr. Koch stated is true is if the state offers you something before that you want to accept a plea offer, Mr. Koch can set it on just about any Thursday. And then I've got other criminal days that Mr. Koch can set it. Okay? So I'll see you no later than May 16th.
No later than May 16th?
Yes, sir.
Yeah.
And that's with sub, Your Honor?
Yes, you're correct.
Yep.
Thank you so much.
So it's at 2:30. Thank you.
Yes, sir.
Jacob Roberson is next.
Thank you. Well, Mr. Roberson.
Good morning. Your Honor, we're here in 24 CF 184. We'll be entering a denial. My client also has a new law in front of this court. That's case number 24 CF 824. Now that case is set for plea day arraignments on May 16th already. Of course, there's no information on that new law yet. I'm asking we just pair them together, place it on that 5/16 date.
Okay. Any problem with running that on the arraignment?
No, it'll just be it'll be on 2 separate dockets. It'll be at 9 a.m. because it won't.
Okay. Mr. Robertson, I'll see you back here on May 16th, okay?
Yes, sir.
Thank you, sir.
Paul Seelot.
Hello, Mr. Seelot.
Paul, morning. Your Honor, we're here in the 2020 CF 2342. We entered denial. If we could place this on the May 23rd date. My client was here earlier in the week, and we set his other case, the 23 CF 2053, on that May 23rd already.
Okay. Mr. Seelot, I'll see you on both of your cases no later than May 23rd. If the state offers you something that you want to accept before that date, Mr. Koch can set a hearing.
Yep. See you, Paul, tomorrow. Thank you, Judge.
I'm going to recall Jeremy Mays with Mr.
Koch. Who is that? Sorry, Paul.
And we set that 523. Yep.
Hello, Mr. Mays.
Your Honor, this is Mr. Mays. We did file a motion to reduce bond and reinstate previously revoked bonds. I talked to Mr. Gomez. I believe the state's going to have no objection to the motion. I did talk with Mr. Mays briefly, and I know he wants to address the court. The state had indicated to me, frankly, just flat out told me, that they wanted Mr. Mays to be on a GPS monitor. Mr. Mays is going to request that the court not require the monitor. He would like to address the court directly. I have advised him not to talk about the facts of the specific case. I believe he wants to talk about the underlying conviction from the late 1990s, but I did tell Mr. Mays I have no problem with adults who want to address the court as long as they're fully aware of everything they say could be used against them.
Understand. Mr. Mays, before we do that, I made a lot of copies. I highlighted different things doing my homework, so if you'll, first off, to the state, so you stipulate to the motion, however you are seeking a GPS monitor.
That's correct, Your Honor, and that's namely because, probation, to be quite frank, requested that we object to the bond. I explained to them why we were not objecting. However, they did state that they wanted a GPS to be placed on Mr. Mays, and I don't disagree. Given these facts, there is a lot that I have to flesh out, which is why I am agreeing to a bond. However, given the charges, the underlying charge that gives rise to these charges, we would request and do agree with probation that a GPS monitor should be placed on Mr. Mays.
Okay, thank you. Mr. Mays, again, let me refresh my memory, okay?
And briefly, before I stop talking, Your Honor, I did review 943.0435. I did not see any statutory requirements that a monitor be attached. Of course, I read it rather quick, and it is a lengthy statute, so maybe I missed something, but I did not see statutory requirement for a monitor.
And what you attached to the motion, certainly supported your argument.
That's why I attached it.
Yes, sir.
Yes.
Yes, ma'am.
I'm getting emails from the sex offender officer. She is stating that the GPS is a condition of his supervision.
Okay, a GPS is a condition of his what does that mean exactly? I mean, does it mean statutorily? So this is.
His supervision.
These are some VOPs, and he's got to be on the GPS anyway?
Well, his supervision terminated on April 13th of this year in 21 CF 1932. I know he would still have to report. Obviously, it's been told.
But if it's told, and then we release him, I mean, he's not, it would seem counterintuitive to say he doesn't have to continue with the conditions of, similar conditions to what his probation was.
I agree. I mean, I'm just pointing out on the violation report, his term date was April 13th of 2024.
Understand. Okay. Mr. Mays, do you want to testify? Is that what you're?
Would like to try to plead to you.
Okay, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
Thank you, sir. You can put your hand down. Please. Yes, sir.
Judge Brown, when I first moved to Florida, I moved to Crestfield, and unfortunately for me, I saw a girl getting out of a police officer's car, which was Officer Toby Baker. At the time, this was 24 years ago. I had never been in any trouble other than I think I had one domestic violence, and that's because I was young and dumb, got drunk, and I did everything I was supposed to do. I haven't been in trouble in 23 years, and when I did get in trouble for that, I don't know if you see how fast I was convicted of it, but it was like that. My public defender at the time told me if I took the DNA test that I would be proven innocent, or we could overturn my case if the DNA test proved I didn't do anything, because I've never done anything with that young lady. And I had a DNA test, and so there were like 15 other people, and they still haven't found the father to that baby, and it's because that baby belonged to a police officer. And that railroaded me, and nobody ever gave me a chance.
Just to kind of give the court some background, because I did actually look into the underlying conviction. So Mr. Mays was arrested, I believe, in 1997. It might have been 1998. It's kind of hard to, actually a lot of the documents are still available on Benchmark to look at. The thing I couldn't track down was what subsection of 800.04 he was actually charged with. It's not in the information from the original charge. He ended up pleading to the attempted crime. I cannot recall what it was. The allegation basically was that Mr. Mays had impregnated, I believe, a 16-year-old girl at the time. He was roughly about 19, 20 years old. So that's what he's talking about, the DNA test. He's talking about the victim in the case she became pregnant. And so I don't know why it was pled to an attempt. I've reviewed the statutory language, and unfortunately attempts are covered. As a matter of fact, the state had to file a motion after the plea agreement was filed asking for a designation in this particular matter. And I reviewed that motion. It looked legally sufficient to me. I would love to be able to attack the underlying conviction. I don't know if I have a mechanism to do that. Obviously it's been a quarter of a century.
Let me ask you this. So if that case was back in 1997 or thereabout, because I didn't do homework on looking at the underlying.
Certainly.
What about the 21 case?
Well, the 21, and that's, the statute actually authorizes removing somebody from a registration, but there are you cannot be arrested for anything for 25 years as a minimum. I did not represent Mr. Mays in the 21 CF case. I don't know why he was on probation for that, but he is on probation for failing to register.
Okay, that was what the allegation was, or in the 21 case. 23 case, same thing, failure to register?
These are all failure to registers. When I reviewed his criminal history, he does have a couple of misdemeanors here. They're mainly, he's got a lot of speeding tickets. But there is a significant gap in any sort of concerning criminal history. I mean, he did go pretty much up until about 2020 with no issues.
Okay.
And I didn't mean to cut Mr. Mays. I just wanted to fill you in so you're not like, what is he talking about DNA?
Gotcha. Okay, Mr. Mays, what else do you want me to do?
As far as the 2020 conviction, I've had the same SO officer, Officer Henry, coming to my house for the last 13 years. I've lived in the same house for 15 years up until recently. And he sort of kind of knew about things in my case, and he was giving me the benefit of the doubt. That was the reason I did meet the failure to appear. Everybody's always telling me you gotta get a lawyer and get back in front of a judge. I paid $8,500 to a lawyer, and I ended up with the 3 years of probation and house arrest. I didn't do it intentionally. Officer of the court on body cam did know I had my Facebook and stuff for the 2021 charge, and I just, was not necessarily trying to get in court that way, but I wanted to be able to tell a judge my side of the story and why I shouldn't be a registered sex offender. Nobody's ever given me that opportunity to talk to them. The State Department, none of them. The state attorney, I've never been able to tell my side of the story at all. I just took those charges because I was scared at 19 years old to go to prison. My public defender told me I could get hurt and may not come home. It was best that I took the plea that they were offering. It's the only reason I took it. I would have asked to go to trial. She had the baby 6 months after I was put on the registry in January. She had her baby in June. I would have fought that the entire way had I been given the proper legal advice at that time.
Understand. Mr. Mays, were you wearing a GPS monitor when they arrested you this last time?
Yes, sir.
Okay.
And Your Honor, if I may,
Please.
I want to point out that I believe he's going to be past term on some of these, and so if he's released, he's not going to have any sort of monitoring. I also want to draw attention to the Jessica Lunsford Act. Anytime that you have a defendant who is the crime that they were put on the registry for involves a victim under the age of 15, anytime they're on supervision, the court is required to have a GPS monitor placed on that defendant. In this situation, I believe the information alleged that she was 12 in the underlying, and so given that the state is requesting that this GPS monitor be placed on him, I mean, we are agreeing to let him out on bond so that we can figure out and really flesh out what happened with these failures to register. However, we need some assurance that we're going to know where he's at. He was homeless when he was found for these cases, and so given that, I think there's ample evidence to support the fact that he should be placed on a GPS monitor if he's released. So.
I understand. Thank you. Mr. Mays, your motion is granted with the caveat that you will need to wear a GPS monitor at the minimum amount per day.
Your Honor, from what I understand though, because he's past term on probation, he'll have to be on the GPS with pretrial services.
I agree. So pretrial services will be the one that will monitor the GPS monitor. When will I see Mr. Mays next?
He is on the May 13th docket, Your Honor.
Okay. Mr. Mays, talk to Mr. Kleins about all those things that you just talked about. Mr. Kleins is a very competent attorney. If he needs to refer you to somebody else that may be able to address some of those older concerns, the ones back from 1997, or, talk to him about that, okay? And I'll see you back here no later than May 13th.
Are there bonds that are being reduced? Like which
Okay.
ones are being reduced?
Mr. Kleins?
Yes, sir.
Why don't you tell the clerk expressly what granting your motion?
Yes, sir, Your Honor. So, Madam Clerk, the request was to reduce cash or professional bonds in 24 CF 512 and 24 CF 555. Those are whatever the cash or professional amounts are in those cases, and I'm trying to review the motion real quick to see if I included them. So in 24 CF 512, there's a $2,000 cash or professional bond that would be reduced to a signature bond. In 24 CF 555, there was a $3,500 cash or professional bond that would be reduced to a $3,500 signature bond. His bonds in 21 CF 1932 and 23 CF 2367 will be reinstated.
Thank you, sir.
And we'll submit an order to the court with the language.
Yes, sir. Thank you.
That's all I have for the money.
Mr. Mays, before you leave, I heard you, okay? I heard what you testified to. Thank you, sir. Okay, that's all we have on the 9 o'clock.
That's all I got. Okay, at the 1:30.
You want to do
This
those?
is no big Mrs. Speed.
Please.
Christina Rice or Mr. Cox?
Good morning, Ms. Rice.
Good morning.
Did they give you the copy?
Yes, sir.
Your Honor, this is Mrs. Rice. Information has been filed this morning. I did provide I have an offer.
Good.
And I'd like to talk to her during the lunch hour.
Okay.
And so if we can put her on that 1:30 docket.
Okay. Ms. Rice, I'll see you this afternoon at 1:30.
Okay.
I'm going to talk about that also.
Can I talk with you?
Yes, but we'll talk about it.
Okay.
Okay.
Sawyer's next.
Okay, thank you. Hello, Mr. Sawyer. Good morning.
Good morning, Alex. This was today. Your Honor, we received the information today. We'll be entering a not guilty to all 4 counts, waive formal reading. My client has 2 other cases in front of this court, Judge. The 23 CF 2432, it's a VOP, and a 24 CF 4010, it's a new law. Both of those are already set for the 513. If we can take this case and also add it with that.
Okay. Mr. Sawyer, I'll see you back here on May 13th on all of your cases, okay?
What does that mean exactly? Because I never really understand. I'm just like hurrying up and waiting for the process or something. Can I go ahead and do something and take a plea?
If the state has offered you
Like, 'cause
anything, does the
I got a
state have
six-year-old
to?
daughter.
Department of Corrections incarceration offer, Your Honor.
Okay. So, Mr. Sawyer, they're offering you, whatever they're offering you to go to prison.
Okay, well, how long? I mean, because I got a 6-year-old daughter. I got a family and a
Yes,
job.
sir. Okay.
Like,
You asked them, and let's see if they know the time period.
Hold on, Your Honor, I'm having to look. This is not my case.
it's hard to tell a 6-year-old where you're at.
Yes, sir. I bet.
Mr. Gomez, I believe, before this new law was filed on, I think it was 18 months. If that reflects in Mr. Snell's.
Yeah, it's gonna end up being right at, I think it's like 32 months. With the new
32
law.
months in prison is the state's offer.
Yes, Your Honor.
Even if I'm innocent of this?
1 second, don't make any statements, please.
That's why Mr. Koch is asking to bring you back on May 13th, is
And
where
then-
he can flesh out those things about you.
And then when I come here on the 13th, it gets pushed off for another month?
We will set, if Mr. Koch and the state are ready to go to trial,
I
we'll
want
go to trial at the end
Can I
of
put in
May.
a speedy trial right now? And I want a bond reduction, because I'm still being held with no bond.
Your mouthpiece is Mr. Koch.
Please.
So I'll see you on May 13th.
And I would like a speedy trial.
I know, they filed this morning. I'm gonna come talk to you, but take that with you, okay? That's your charges.
All right. Thank you, Ron.
Thank you, sir. Good morning, sir. Good, how are you?
Your Honor, can I just have a brief moment? Today's the 18th. Thank you, Judge. Your Honor, Mr. St. Jean is here on 2 cases. It's 24 CF 586 and the 24 CF 651. This will be a change of plea to no contest. Client will be adjudicated guilty, 18 months of the standard probation, $40 per month cost of supervision. There's $1,030 in court costs, $250 defense costs, 50 hours of community service. Both counts to run concurrent. In both cases, run concurrent. Your Honor, if I may approach with the plea form and the score sheet.
Yes, sir. Thank you. Mr. St. Jean, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you. You can put your hand down. Mr. St. Jean, did you read the plea agreement? Do you understand it?
Yes, I did.
Did you discuss it with your attorney?
I did.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yeah.
Did you sign the plea agreement?
I did.
Mr. St. Jean, on that last one, you said, yeah, I guess. Any questions you have for the court or your attorney or the state?
I just want to move forward with all this and get out of jail and, try to get back to my normal lifestyle.
Okay.
I'm pretty behind on a lot
Okay.
of stuff.
And you understand everything that's in the written plea agreement?
I do.
Okay. Mr. St. Jean, I do accept your plea. You're adjudicated guilty. You're sentenced to 18 months probation. That's to run concurrently, run at the same time in each case and count. You'll need to pay the $40 per month cost of supervision, the court costs in the new case. They're both new cases?
Yes.
Yes,
Okay.
Judge.
Court costs in both of the cases, total of $250 public defender's fee, and perform 50 hours of community service work. Okay. Thank you, sir. Good luck to you.
Thank you.
Clayton Palmer is next.
Did you have time to read this too?
Yeah, I read the.
That's $615 worth cost, $150 cost of defense,
Right.
24 months probation, substance abuse violation,
Right.
24 community service work, action on the FTA, and talk about including misdemeanor BOP.
Okay.
For the 90 days. Is that what you expected?
Yeah.
Okay. Need to sign it and date it. All right. Here at the top. This is Clayton Allman before the court in 23 CF 987. Madam Clerk, the intention is to enter a plea that also includes a misdemeanor. That misdemeanor will be 22 MM 1796, which is a misdemeanor violation of probation. May I have just a moment, Judge?
Yes, sir. Mr. Homer, while he's doing that, if you'll raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Thank you, sir. You can put your hand down.
Yep.
Did it the other day.
Yes, sir.
Do you know if I have enough?
They're gonna calculate that at the jail. Just initial right there.
I didn't see that, no. Sure.
Yes, sir.
Judge, may I approach the plea agreement? Yes. It calls for Mr. Allman to enter a plea of no contest as charged to the state, count 3 and 4.
What can I help you with?
Counts 3 and 4 on the new case are second-degree misdemeanors. And I was going to ask the state for time served, given that it can be placed under 24 months probation on those counts.
No objection.
So, Judge, it would be a plea of no contest as charged, 24 months probation with special conditions of a substance abuse evaluation, 24 hours of community service work, take no action on any failure to appear. Standard court cost was a $615, $150 cost of defense. As stated, counts 3 and 4 are second-degree misdemeanors, and those counts will be time served. He would not be placed on probation. In 22 MM 1796, we would stipulate that this court's jurisdiction to handle the misdemeanor. That is a misdemeanor violation of probation, and the agreement is for 90 days in the Okaloosa County Jail with credit for time served to revoke and terminate that supervision. With an additional, and I have not written in this into the agreement, but there would be an additional $50 VOP fee, a $50 cost of prosecution. And we would ask the court for a time period before the financials are sent to collections in that case.
So an adjudication of guilt on both?
It would be an adjudication of guilt on the misdemeanor counts.
Okay.
It'd be a withhold of adjudication on counts 1 and 2, which are the felony counts.
Got you. Okay.
May I approach?
Yes, sir. Mr. Ulmer, if you've already swore you in, so Mr. Ulmer, did you read the plea agreement?
Yes, sir.
Do you understand it?
Yes, sir.
Did you discuss it with your attorney?
Yes, sir.
Did he answer all of your questions?
Yes, sir.
Are you satisfied with his representation?
Yes, sir.
Did you sign the plea agreement?
Yes, sir, I did.
Okay, let's go to the one thing that Mr. McKinney said is not written in here. So do you agree to the $100 basically cost of prosecution in the misdemeanor case?
Yes, sir.
Mr. Ulmer, I do accept your plea. Adjudication is withheld. In the felony case, you're sentenced to time served on counts 3 and 4, sentenced to 24 months probation in counts 1 and 2 to run concurrently, run at the same time. You'll need to submit to a substance abuse evaluation within 30 days. Has Mr. Ulmer already served the 90 days in the misdemeanor case?
Judge, he's been incarcerated since at least February 14th, so he's close to that, but I believe that Okaloosa County Jail would still need to calculate exactly how much credit he has.
Okay. So, Mr. Ulmer, you'll need to submit to a substance abuse evaluation within 30 days from your release from jail.
Yes, sir.
And if any treatment's recommended, begin that within 60 days from your release from jail. You'll need to perform 24 hours of community service work, pay the court costs, $150 public defender's fee. And there will be $40 per month cost of supervision. In the misdemeanor case, adjudicated guilty, and you were adjudicated guilty of the misdemeanors in the felony case, counts 3 and 4. Misdemeanor case, adjudicated guilty, sentenced to 90 days in the Okaloosa County Jail with credit for all time served. Your supervision in that misdemeanor case is revoked. You'll need to pay the $100 cost of prosecution. How long will you need to pay that after you get out?
Well, when I get out, a month.
Okay. So why don't we say 60 days, okay?
That total amount on that case, Judge, and I'm looking at it on the clerk's side, is approximately $90, is that correct?
Yeah,
I
paid it up.
He paid $1,100, so he's only got $90 to pay on the misdemeanor case.
Including the, and then an additional $100.
Correct,
right?
plus that additional
So
$100.
190?
Correct.
So if you fail to pay those amounts within 60 days from your release from jail, then those amounts will go to a civil lien or judgment. Okay.
Sure.
Thank you, Mr. Ulmer. Good luck to you, sir.
Thank you, Your Honor.
Okay. Is it withhold on the felonies?
But the count 4 is a DWLS, so it's adjudication.
Probation on the way out.
Thank you.
And then is Ms. Wilson here? I'm just gonna do the one case. You can come in. If you have a case, feel free to come in. What case are you here for?
Well, he's waiving, we're coming back on the 15th, March 15th. My attorney waived said he's gonna waive the hearing or something. He was trying to make it build.
Do you have a case today?
Your Honor,
Okay. And whose client? Is it Mr. Pizderka? Is he your client?
Yes, Your Honor.
Okay, I'm just gonna have you take a seat. We'll call your case in a few minutes. And if you could, please take your hat off. Thank you. So I'm just gonna do this one case and then, somebody else is gonna come out and complete the calendar. So Ms. Rowe, you're here. Ms. Morrison, can you come on the Zoom call, please? Michelle Morrison, can you unmute and come on the Zoom call? And I think Charlene Wilson is here also. And so we're here for sentencing. I also had, do you remember Ms. Morrison there? Ms. Rowe, when we were in court and she pleaded guilty, I told her that there was a court hearing on February 5th for renewal of the civil order, and I told her she needed to be there. Do we all remember that? Ms. Rowe, do you remember that?
I believe, I remember she had another case, yes.
Right, and I guess I'm wondering, I asked her to show up on February 5th. I guess before we get started, I'm kind of wondering why she didn't.
Miss Morrison?
Did we lose her? Well, I'm gonna step off and, you know, a no bail warrant's gonna issue. I'm gonna be here all morning. And if she comes back on, you can track me. I'm gonna be in one of the other courtrooms.
Okay, I will, I'm sure.
And then, are you on this calendar there, Ms. Rowe?
Yes, I have, I've got quite a few cases in courtroom 3 today. You're right. Yeah.
Okay, so if she comes back on, you can.
She will. I know that something must have happened, so I'll reach out.
Okay, she's coming back here.
Oh, okay.
Apparently.
Alrighty.
Yes, I'm here. I don't know what's going on. The Zoom stopped working and I had to restart it.
Okay, so again, do you remember when I asked you to be in court on February 5th, excuse me, to address the civil order?
Yes.
Why we missed you? Is there an explanation for your non-attendance there?
Yes, I had worked from like 3 o'clock in the morning until about 7:30, and while I was waiting for the Zoom call, I had fallen asleep. And I when I woke up, I emailed the court and told them what happened, and they extended it until the 5th of March, I believe.
That was a different court case.
Yeah, there was.
That was, she missed 2. That was the Olympia case.
All right. Okay. So that case is on here today. There is Ms. Morrison. I'm going to speak directly to you. Ms. Wilson is here. We're here for sentencing. I took the plea. We're going to go around the horn for recommendations. The civil case is on the calendar as well. We're going to talk about that, whether or not there's been a petition to extend that. And then we're going to take that up here today also. And so, again, I need to call the plea form. So I'll hear from the state first, then I'll hear from Ms. Wilson if she wishes to speak. Then I'll hear from Ms. Rowe, and then Ms. Morrison, you'll have the opportunity to address the court if you would like. So Mr. Fortunato.
Your Honor, I'm going to be making this very brief. I think that the recommendation for 364 days imposed with 363 suspended, 1 day credit for time served, 24 months probation, no criminal law violations, abide by the post-conviction no contact order protecting Ms. Wilson, and paying $245 in restitution to Ms. Wilson for the damaged goods as appropriate. That was the recommendation. That was the agreement. Ms. Rowe is going to be asking for a deferred sentence. Ms. Wilson's going to be asking for, or Ms. Morrison's going to be asking for a deferred sentence. I don't think that's appropriate here. The state has already agreed to dismiss the malicious mischief charge in agreement to Ms. Morrison pleading guilty to this charge, which she has done. But understanding that there is also a pending Olympia Muni case involving these two same parties, Ms. Morrison and Ms. Wilson, state thinks that it is very appropriate to ask that Ms. Wilson plead guilty, serve the sentence, and at the end close the case rather than dismiss it. That is going to be the recommendation of the state. Ms. Wilson is certainly going to be free to elaborate a little bit more on why that's an appropriate request. Additionally, I believe I'm not going to be representing her on this civil matter, but I believe she has more to share on that as well. But that is going to be the request of the state, Your Honor, and I certainly defer my time to Ms. Wilson.
Ms. Wilson, anything you'd like to say? You filed a letter.
Yeah.
I had read a while ago, which I have up in front of me now. I'll hear from you, ma'am.
Yeah. So this issue's been going on for quite some time. Of course, this is the first one that's been gone to trial. This is the second violation in this. I do not feel safe around her or for her to be anywhere near my house or my children. The civil case was for to extend the order to protect my kids, not just me. For her knowing that she had a no contact order and her coming to my home is very disheartening, and I do not feel safe. I had to put cameras outside my house because of her stealing from me and doing these violation of stuff. So I really would like to have the court extend, like maybe having her get some jail time, because I do not think that she's going to learn her lesson without that. And hopefully extending this order for even more than 2 years, if possible, protecting me and my children, because I do not feel safe around her whatsoever. Yeah.
Ms. Rowe?
Your Honor, this is an unusual situation. It's not an unusual situation. These type of things happen all the time. Miss Morrison is actually in the process of working with the police because now she's filing for an order against Miss Charlene. It's my understanding, and Miss Morrison has called me at times right after these incidents have happened. It's my understanding that Miss Charlene is actually, her actions show that she is not afraid of Miss Morrison. Miss Charlene came to Miss Morrison, was at a gas station or a store not long ago, threw herself on the trunk of Miss Morrison's car and would not let or stood behind Miss Morrison's car and would not let Miss Morrison leave. Miss Morrison is actually in the process of working with some officers to get the footage of that. Miss Morrison has also called me no less than 3 times, indicating that Miss Charlene has come to her apartment, yelling and screaming for Mr. Joseph Shelby to come out of her apartment. So although Miss Wilson stands before the court as an alleged victim, Miss Morrison's position is that Miss Charlene is doing everything she can to try to instigate contact with Miss Morrison. And Miss Morrison has finally gotten a couple of neighbors to write declarations about Miss Charlene's presence in her apartment complex. These neighbors have seen Miss Charlene lurking around Miss Morrison's home.
So,
and Miss Morrison,
Ms. Rowe, I hope you're not forgetting who's being sentenced here.
I am not, Your Honor.
Ms. Morrison pleaded guilty. I've reviewed what the allegation is. I mean, it was in the police report, and I don't. I will just tell you up front, you can continue, and I apologize for interrupting. You're not going to get very far with me by blaming the victim here, which
Your
is
Honor,
kind of what you're doing. And so
I am
again,
not
I'm
attempting
just going to tell, I'm just a word to the wise there, and you can continue. Go ahead.
Thank you, Your Honor. I am not trying to, this is why I started out this recitation saying this is unusual. It's unusual on my part. But as this court knows, because this court has dealt with many of these types of cases, this is two women interaction because of a gentleman. We are present, ready to go forward. Ms. Morrison absolutely understands the no contact order and assures the court she has not violated it and will not in the future. I just want this court to understand that this appears to be a situation where there are two women basically fighting over a gentleman. That being said, Ms. Morrison took responsibility for her actions regarding the incident that we were going to trial on. She's assuring the court will not see any future violations. She was doing everything that she believes is humanly possible to avoid contact with Miss Charlene. Unfortunately, as this court knows, no contact orders basically are one way. And so Ms. Morrison wanted the court to understand a little more of the tenure of this case. As the court can see, Ms. Morrison has little to no criminal history. And at the age she is, I believe that shows that she is a law-abiding citizen and tries to be for the most part. We had discussed with Mr. Fortunato requesting a deferred sentence in this case. And we will be asking that the court consider deferring sentencing on this case, allowing Ms. Morrison to show the court that she can abide by the court's orders. And we are requesting that the court consider deferring sentence so that this can ultimately be dismissed.
Ms. Morrison, anything you'd like to say at this time?
Yes. I heard in the beginning when you spoke, Your Honor, about the deal that I am making with the court about, you said something about 24 months of probation. I wasn't aware of any probation. I was only aware of 24 months of me not contacting Charlene Wilson. So I was kind of confused about that part.
Okay, I'll explain that to you.
Mm-hmm.
Anything further?
If I'm allowed to speak about this whole thing in general, this whole case going on right now with Charlene Wilson, I just want to say that I know that she has gone through a lot with Joseph Chelde throughout the years, and it hasn't been good on her part. Like, it's been very hard for her mentally, physically, in every way with him. And I know that she feels like I'm the problem and I've hurt her somehow. And the real fact is, Joseph Chelde is the one that's been hurting you, or hurt, not you, but her. And I think that is the main problem and not me. And I feel like that's something that if she could, get in her life figured out, and it would make it a lot better for her and her children when it comes to her and Joseph. And that's pretty much what I'd like to say about that.
What's your position on the extension of the civil no contact order, the order that's been in place? It's like Judge Buckley entered that back in June of 2023. There's been trying to get that reissued.
Sorry, Grandma. Sorry.
That was June 20th of 2023. So she wants to extend that. And so I guess what's your position on that?
Your Honor, I'm in the process of, I'm going to get a no contact order on Charlene Wilson because it's been a major problem with her coming over to my home and, doing things. There's a lease
Okay.
violation.
That's one thing I'm not interested in what you're going to do. I ask you a specific question about this order.
Okay, so this order, I have no problem with staying away from Charlene, and that's not an issue for me. And I spoke to my lawyer in the municipal court case. I think his name is Terrence Wong, and I told him that there was a 2-year no contact order with the district court, with this court. So I don't think that there would be a need for another no contact order to be placed. And that's, as far as that, that's all I understand about what's going on with that.
So,
Your Honor, I would also piggyback on Ms. Morrison's argument, and that is that because that Ms. Morrison is willing to abide by any
Your Honor, I would object
existing
Ms.
no
Rose
contact
representing
order.
Ms. Morrison on a case.
don't worry about it, Mr. Fortunato.
I'll reserve anything else, Your Honor. Thank you.
So, and again, I just want to, put on the record what's actually alleged. This pled at a late date. An alibi witness was produced at the last minute with no notice to the state. In the state's trial memorandum, it indicates that on October 30th, shortly before 1 a.m, officers were called to the residence of Ms. Wilson. There was a description of a car that had come to the house, driven away, and maybe my words, but kind of peeled out. There were neighbors who observed the car. Officers got the license plate or identified the car, went to the owner of the car, which was Ms. Morrison, felt that the engine was warm, recent use, and then Ms. Morrison indicated that she was at the casino. She produced a receipt from the casino, which was about 11:59, which is about 55 minutes before the officers were called about the incident, which is plenty of time to go from the casino to Ms. Wilson's residence. And now, and then when we come, the person who's charged with the violation of the no contact order, the person who is pleaded guilty is basically come to court and say, well, gosh, it's not me, it's her. And so I think that alibi witness, given the way it was produced and without notice, I think might have sustained some credibility problems. And yeah, I'm just going to leave it at that. But with regard to the sentence, I'm not going to do a deferred sentence. This is the first conviction for violation of the no contact order. So I'm not going to impose any more jail time than has already been imposed. Although there's some, by the time you get around to sentencing, if there is a sentencing in the city of Olympia judge is going to see that there's previous convictions for this order, and will probably take that into consideration in what he or she decides to do with this case. So there's that. But so I'll go along with what's recommended. In the criminal case, it'll be 364 days in jail with 363 suspended, credit for 1 day served. It'll be suspended for a period of 2 years, and the term probation gets thrown around in the sense that you're not going to be on probation in the sense that you're going to have a probation officer, you're going to have to check in or anything like that. That's not the case. The probationary period means that's the period of suspension. So for the next 2 years, if there's any violations of this order, then you can get summons back here, and some of this suspended time can be unsuspended. You understand that, Ms. Morrison?
Yes, I do, Your Honor.
And so again, you'd be subject to jail time if there's any more violations of this order, and you won't have a trial on that. This will be a evidentiary hearing determined, and the standard is different. If the order's been violated, you'd be looking at some incarceration time. And there'll also be $246 in restitution. And again, that'll be in place for the next 2 years. I'm also going to sign an order on the civil case that extends the civil order for 2 years from today. So both of these orders are going to be in place for 2 years. And they are, I've heard this thing, well, why do we need 2 orders? And Ms., on the civil order, that includes the children. And so that'll be part of that civil order as well, whereas the criminal order doesn't. So, and of course, Ms. Morrison, you're free to pursue any sort of order that you wish to pursue. But that's going to be what's going to happen here today. And give me just a minute. I'm going to need a minute to fill out those orders. Anybody have any questions?
I do, Your Honor, and Mr. Fortunato, it's more for Mr. Fortunato, but I believed, Mr. Fortunato, I thought the restitution was off the table. Was I
Restitution's
mistaken?
written right in the plea form there, Ms. Rowe.
Okay, some time has gone by. Apparently, I'm mistaken.
Again, for the next to be 364 days in jail, 363 suspended, credit for 1 day served. Be suspended for a period of 2 years. Don't have any criminal law violations. Comply with any existing no contact order. Pay restitution, the amount of $246.
And may I
Yep.
inquire, there was also a case that was to be dismissed,
That has been dismissed already.
that had been dismissed already.
Yeah, it was dismissed upon the plea.
Thank you.
And that'll be, the civil order will be in place until February 14th of 2026. And Ms. Morrison and Ms. Wilson, you can get copies of that off the Thurston County District Court website. That's it for today. Ms. Morrison, Ms. Wilson are free to leave. And
I've got to pop to courtroom 4, Your Honor, and then I will be back.
that's it for today.
Thank you, Your Honor.
Please be seated. Welcome back, everyone. I'm Judge Pro Tem McDonald. Today's hearing is going to be broadcast over Zoom and YouTube to increase access and awareness. And welcome to Thurston County District Court. Let's see. I see that we've got a couple of people ready to go. Ms. Lesh, do you have any matters you're ready to call?
Morning, Your Honor. Yes, I do. I'd ask the court to call number 3 on the 9 o'clock calendar, and that's Mr. Kamana, and he's present with us over Zoom.
All right. And good morning, Mr. Kamana.
Good morning.
All right. And counsel, I see we're on for a trial confirmation. How are we proceeding today?
Thank you. Simply for the record, I'm standing in for Attorney Kale. We're asking the court to accept the recommended resolution and to permit Mr. Kamana, Kamana to enter into a 12-month stipulated order of continuance, ending in a dismissal of both charges if he's compliant with the conditions. That stipulated order of continuance paperwork should be in the judge's folder on Laserfish. It has been signed by all parties. It was signed by Attorney Kale on behalf of Mr. Kamana, with his express consent.
All right. Well, I suppose, Mr. Kamana, I will turn to you. Unless counsel for the state, do you have anything record to make at this time?
Not at this time, Your Honor.
All right. Mr. Kamana, before we read through this, I want to make sure we're on the same page. Is it your intention to order a stipulated order of continuance today?
Yes.
All right. So I've got this paperwork in front of me. I want to go over a bit of this with you. I want to make sure, first and foremost, you understand you're currently charged with a driving license suspended in the 2nd degree. That's a gross misdemeanor, which means it carries a maximum possible sentence of 364 days and a $5,000 fine if you're found guilty of the allegations. But is it your understanding that that's what you've been charged with?
Yes.
All right. You understand that a stipulated order of continuance is a contract between you and the prosecutor. This particular one states that if you are able to meet the conditions that you're agreeing to as part of this, that after 12 months, the charge against you will be dismissed. Is that your expectation?
Yes.
And you understand that you're agreeing as part of this that agreement that for the next 12 months you will have no new criminal law violations and you will not drive without license and insurance?
Yes.
All right. Counselor, are there any other expectations of this SOC? Oh, excuse me. Mr. Kamana, you will also be expected to follow any Department of Licensing expectations as to ignition interlock. Do you understand that as well?
Yes.
All right. You understand that it seems you understand the agreement that you're entering in as to what you're expected to do. And we've talked about what happens if you uphold your end of the bargain. I want to talk about what happens if you don't uphold your end of the bargain. That's to say that you're agreeing as part of this that rather than have this case go before a jury, as part of this SOC, you're agreeing to have a hearing, which is just between you, the prosecutor, your defense attorney, and the judge. It's called a stipulated facts hearing. At that hearing, the judge will make a determination of innocence or guilt based solely on the police report. And those were never written to make anyone look good. Is that your expectation, sir?
Yes.
All right. You understand that as part of this, you are not guilty, that you're not, that this is not a statement of guilt or anything like that. The SOC itself, I should specify. Excellent. You understand that right now you have your full trial rights. Those are the right to an impartial or trial by an impartial jury of your peers in the county where the crimes alleged to have taken place, the right to remain silent before and during trial, and the right to refuse to testify against yourself, the right to question any witnesses who testify against you, the right to bring witnesses to testify at your own behalf at no expense to yourself through the subpoena process, the presumption of innocence until proven guilty beyond a reasonable doubt, or the entry of a plea.
Yes, sir.
All right. Do you have any questions about those rights?
No.
All right. Do you feel you're entering this plea freely and voluntarily? Sorry, this plea. Excuse me. Do you feel you're entering this or stipulated order of continuance freely and voluntarily?
Yes.
Excellent. There's a secret section in here that a lot of people skip over, so I want to make sure we're on the same page. There's one extra requirement of any SOC, and that's that you'll notify the court of any changes to your address for the duration of the contract. Are you willing to do that, sir?
Yes, my attorney went over that with me yesterday, so yes, I'm aware of it.
All right. If that's the case, do you have any reason that you foresee that you would not be able to uphold this your end of this contract?
I'll be fine with my end.
All right. If that's the case, sir, I find that you know what you're agreeing to. I have no issue affixing my signature to this form, which I am doing now. It's not letting me affix my signature to my time to the SOC, so we'll have to date that manually later.
Okay.
All right, I've affixed my signature to the SOC. Congratulations, Mr. Kamana. I hope that this agreement works out well for you. Council, anything else we need to address at this time?
Nothing.
Either state or defense. All right, fantastic.
From the state, Your Honor.
All right, let me finish filling out this SOC or the JNS very briefly. All right, Mr. Kamana, if for any reason you need a copy of any of this paperwork, you can contact the court. It's available online. Your attorney can also help you get a copy of that. Otherwise, I've affixed my signature to the JNS, which is a form that goes alongside the SOC. Congratulations, sir. I hope this program treats you well. Otherwise, you're free to go. Thank you for being here today.
Thank you. You have a good day.
You take care.
Bye-bye.
All right. And
Your Honor, if I could address a matter.
absolutely, Mr. Gasling. I was about to apologize for looking right past you and at the screen this morning.
Well, I was waiting on my client and he has joined us on Zoom, Mr. Raymond Lavole. He's on the 10 a.m. calendar, but I was hoping to address this matter early because I do need to hop over to the Veterans Court.
Excuse me, there is one more matter I need to address on Mr. Kamana's matter. Counsel, how are we handling that contested? Was there any intention to get rid of that?
State will be making a motion to dismiss the infraction upon entry of the SOC, Your Honor.
Granted, it's been entered. Mr. Kamana, I apologize if you're still listening. The contested, or the tracking ticket is now dismissed. All right. Sorry, Mr. Gasly.
Not a problem. So Mr. Raymond Lavole is with us on Zoom. He's on the 10 a.m.
Good morning, Mr. Lavole.
Good morning.
Your Honor, we are here for a trial confirmation. I filed several motions. I think the most pertinent one is the defense motion to continue. Hopefully that's made it into Your Honor's hands, but the basis is newly acquired information after I spoke with the state toxicologist in this matter. It requires further consultation with an expert witness in this case. I have located an expert who's willing to work with me, but she informs me she has about a 9-week wait period. I think sounds like that's fairly common for experts now. They are in high demand. So Mr. Lavole has executed a waiver of speedy trial with speedy to commence in approximately 9 weeks, just to alleviate any pressure on the court. I do believe this is headed for trial, but in order for me to provide effective assistance, I do need to consult with people who have far more scientific knowledge than I do.
State, any argument?
Your Honor, I don't have an argument. I would just, of course, like to make the court aware, and I believe counsel has mentioned this. This is the third motion that's been filed by defense, or will be the third motion filed by defense on this case. Understanding that they are certainly entitled to assist in their own defense, and certainly that is what the nature of this criminal system entails. There is also an interest in having this case resolved, and both parties should have an interest in that. And I do just want to make the court very aware that the state was ready to confirm today, and witnesses had been subpoenaed, had been prepared to confirm and to testify at this currently scheduled trial dates. So with that noted, obviously there is no substantial basis to object to this continuance, but I did just want to make the court aware that this is the third now motion that defense is filing over seemingly situation that could have been known to defense at the time of this case being filed, Your Honor, or at the time of tox results coming back.
All right. Counsel, I take it there's
Your Honor,
further argument?
I don't believe the state has made any showing of prejudice to the state, understanding that witnesses can be subpoenaed fairly simply. Mr. Lavole is entitled to effective assistance of counsel and zealous advocacy on his behalf.
Counsel, I'm going to cut you off there. My intention is to grant this motion. So unless there is a...
No, Your Honor, the more time I spend with experts in this matter, the more complicated the science is getting. And that is the basis for this.
I will find there is good cause for this continuance. However, counsel, I will say that the state is making a compelling argument that this is the third motion to continue this case. I would suggest that you finish up soon. But we'll grant the motion to continue. We'll strike the current trial dates, and we will reset internally. You said you needed at least 6 weeks, counsel?
9.
9 weeks?
And the waiver of speedy trial should be in the hold for court folder, 10 a.m.
All right. State, is there any reason that you see that that's a issue to the state?
None that I can see for now. I would just ask for an intervening trial confirmation date, of course.
Absolutely.
Thank you, Your Honor.
All right. Can we make a note to not schedule that before at least 9 weeks out?
Yep.
Thank you.
And Your Honor, just to be clear, the intent is to recommence the 90-day period. So I think July would be, around June or July would be reasonable for a trial confirmation. That's because the expert is not going to be available to consult and provide me with her analysis until at least 9 weeks out. I will need some time to draft as appropriate, but I do anticipate that I'm trying to give the court as concrete a timeline as I can. which is why we pushed out speedy at least 9 weeks so that we can have a new 90-day period commencing,
All right.
I think, in April.
Council, I am concerned. I find that there is good cause, but I do believe that this should that this period should be told, should it not? If this is your motion, this is, or sorry, that speedy should recommence at that time. Is that
Speedy's yes,
okay? Yes.
recommencing it in April. Yes.
Okay.
I thought perhaps I missed it.
Perhaps I misheard.
No, I believe I heard you say that you were going to schedule a trial confirmation in 9 weeks, which was.
Yes, is that not your goal? Oh,
no.
Okay. So you wish to have the trial confirmation set in sometime in July?
Yeah. For the speedy trial period to recommence on April 14th, I believe, or April 15th. So back at the date.
All right, Madam Clerk, is there any issue with doing so? Okay.
I'm not seeing a way for a speedy trial.
All right.
It might be in courtroom too, because I think he was originally.
Mr. Gessling, I'm still see no issue with granting your motion. Just make sure that we get a copy of that speedy trial waiver. Otherwise, we will. Yeah,
Thank
perfect.
you. I apologize, Madam Clerk. It is in courtroom too.
All right. Fantastic. Any other matters you need to address before you go, Council?
No, thank you very much.
All right. Returning to Ms. Lesh, if you
I do apologize, just for Mr. Lavol's benefit. So, Mr. Lavol, jury trial is not occurring next week. I will touch base with you.
Ready. Thank you.
Thank you.
All right. All right, Ms. And hold on just a moment. Mr. Schweitzer, if you could mute your mic until we have a chance to call you. I'm picking up a lot of background noise from here. Thank you. All right, Ms. Lesh, any other matters you're ready to call?
Yes, if the court would move to number 6 on the 9 o'clock calendar, that's Mr. McCain. We're here for a third pretrial, should be able to handle this fairly quickly. It's my understanding that he's currently in custody at the Thurston County Correction Facility, so we're simply asking that this be reset to the in custody calendar.
All right. We will do just that unless, counsel, you have a compelling reason to do otherwise.
I just want to make sure I'm understanding. Is this Mr. Andrew McCann?
That is correct.
Oh, okay, yes, certainly no objection, Your Honor. State's in agreement.
All right. Ms. Lesh, any other matters you're ready to address?
Indeed, number 10 on the 9 o'clock calendar, 9 and 10, and that's Mr. Philpott. He's present with us over Zoom.
All right. Good morning, Mr. Philpott.
And Mr. Philpott, if you could just unmute yourself and turn your camera on ideally, but at least unmute yourself.
All right, Ms. Lesh, are there any other matters you can call while Mr. Philpott works out his technical difficulties?
There are numbers 11 through 13 on the 9 o'clock calendar. That's Casey Riggs. And waiving his appearance under Rule 3.4, we are in good communication.
All right, Mr. Philpott, just hang on right there. We'll get right back to you.
I'm here.
Ms. Lesh, on the Riggs matter briefly, what is your intent?
Simply asking to keep the future dates as set, and confirmation is set for March 13th, 9:30 in the morning.
And state any reason or anything you need me to know on this one?
No, Your Honor. State's in agreement.
All right. Or we'll allow the Riggs matter to head to its next matter, or to its trial date, excuse me. All right, returning to Mr. Philpott's matter. Good morning, Mr. Philpott.
Good morning.
All right, I see we're on for a first pretrial, Ms. Lesh. How would you, oh yeah, no, this is still, you're handling this for Mr. Kale?
I am indeed standing in for Attorney Kale. Again, simply asking to keep the future dates as set. Confirmation is set for March 15th at 8:30 in the morning.
All right, state.
State is in agreement, Your Honor.
Understood. All right, Mr. Philpott, I know it's no fun to have the attorneys talk past you, but we will be moving on trial date, or so your next hearing dates. It looks like those are set for a time that my computer will show me if it ever loads again. Give me just a moment. Ms. Lesh, do you have those dates handy? JIS, or Jad seems to be taking a moment.
Looks like it's March 15th.
Trial confirmation?
Yes, in courtroom 2.
Oh, there we are. Mr. Philpott, your next hearing is going to be on March 15th at 8:30 in the morning in courtroom 2. I wish you luck. Good luck dealing with your. We'll see you then, sir. Thank you.
All right, thank you.
All right. Ms. Lesh, call next.
The only other matter I have at this time, moving to the 10:30 calendar, is number 2, and that's Terrence Jackson. I'm standing in for Attorney Gale on this matter. It's set for a first pretrial hearing, waiving appearance under Rule 3.4, and simply asking the court to keep the future dates as set. Confirmation set for March 1st, 10 o'clock.
Counsel, anything the court needs to know?
No, Your Honor, state's in agreement with that.
All right. Jackson, number 2 on the 10:30 a.m. calendar. I'm just double checking, Ms. Lesh, that was Terrence Jackson?
That is correct.
Fantastic. All right, we will strike today's date and allow the hearing to continue. All right.
I'll defer to counsel. That's all the matters I have.
All right. Mr. Pezderka, I see you're on. I'm going to call you next, but I do want to do a brief roll call. For those in the courtroom, I just want to get some names. Folks, who are you here for today? Daniel, sorry? Beshanar? All right. And what time's your hearing, sir? 9:30. Fantastic. I will mark you as present. And have you had a chance to speak with your attorney?
Yes, sir.
All right. We'll make sure that you are heard, Mr. Beshanar. All right. And then is she with you?
Yes.
All right. And sir, may I have your name?
From Nesbitt.
Mr. Nesbitt? All right. And have you had a chance to speak with your attorney today, Mr. Nesbitt?
No, I have not.
All right. Mr. Pizderka, with me as I find Mr. Nesbitt. Mr. Nesbitt is here this morning and has not had a chance to speak with their attorney. He's appears to be with Ms. Simmons. Can you just send her a message to make sure she knows he's here? Thank you. Mr. Nesbitt will make sure you have an opportunity to speak with Ms. Simmons. Otherwise, Mr. Pizderka, thank you for your patience. Who would you like to call?
Your Honor, we could start by calling Terry Warland on the 8:30 calendar. I will be waiving his appearance this morning. He was here this morning and I spoke with him and we're just keeping the further dates in place at the time.
All right. State anything you need the court to know?
No, Your Honor.
All right. All right, Mr. Pizderka, we will strike today's date and we will see him at the next one. Who would you like to call next?
Next call, number 1 on the 9 a.m. calendar, Anthony Getchell. He is present on Zoom this morning. And the intention today is to enter into a stipulated order of continuance, which should be in the judge's folder.
All right. Good morning, Mr. Getchell.
Good morning. Am I audible?
All right.
Am I coming through okay?
I'm hearing you just fine, sir. Bear with me just a moment. I'm going to move that out of the action completed into the judge folder. All right. I've got your paperwork filled up or pulled up. Mr. Pezderka, would you like to make a record?
Your Honor, I have reviewed the stipulated order of continuance with Mr. Getchell. I believe he's entering into it knowingly, voluntarily, and intelligently. I believe I have advised him of his rights. He understands that he is giving up his right to a jury trial, that he is not entering a guilty plea. However, if this agreement were to be revoked, he would still have the right to a stipulated facts trial. And so we would just ask that you enter into the continuance as agreed between the parties. I believe that's it.
All right. State, before I move forward, is there anything you need me to know on this one?
Your Honor, there's just one thing I did want to make sure that I was made the court and counsel aware that there is a active no contact order and I am signing a rescission order as we speak. I'm in the process of making that done. I will make sure that that is entered before the end of this, assuming the court grants the stipulated order of continuance, but I do believe it's appropriate. Thank you, Your Honor.
All right. Mr. Getchell, I know it's unpleasant to just have attorneys speak past you, but did you hear all that?
Yes, I did, Your Honor.
All right, excellent. So I want to go over the stipulated order of continuance and make sure that we're all on the same page. You've had a chance to speak with your attorney, but I want to make sure, is it your intention to enter into a SOC today, sir?
Yes, sir, Your Honor.
All right. I want to make sure we're on the same page, so I'm going to read through some of this with you. You're aware you've been charged with assault 4, which is a gross misdemeanor in Washington State, which carries a 364-day maximum possible jail sentence and up to a $5,000 fine.
Yes, Your Honor.
All right. This SOC is an agreement between you and the state. It looks like the agreement that's been reached is that you will both agree to continue this case for 12 months. At the end of that 12 months, the charges against you will be dismissed. Is that the expectation of the general idea for it?
Yes, Your Honor.
All right. As part of this, you'll be agreeing to have no new criminal law violations and to complete 8 hours of a approved anger management course, including course for anger. But this will be through an approved provider. Is that your expectation of your agreement, Mr. Getchell?
Yes, Your Honor.
All right. You understand that if you don't hold up this end of the bargain, you'll have a stipulated facts trial. It sounds like you've had a chance to speak with your attorney about that, but I still want to make sure we're on the same page. That's a trial where it'll be your attorney, the prosecutor, the judge, yourself, and the prosecutor will simply hand up a copy of the police report, which is never written to make anyone look good. And the judge will make a determination of innocence or guilt based on that.
Yes, Your Honor.
All right. And you understand you still have all of your trial rights at this time, that you're agreeing to modify those as part of this. That's the right to a impartial jury, trial by a jury of your peers in the county where the crimes alleged to have taken place, the right to remain silent before and during trial, and the right to refuse to testify against yourself, the right to question witnesses who testify against you, to bring your own witnesses who testify, or to testify for you at no expense to yourself through the subpoena process, the presumption of innocence until proven guilty or you enter a plea.
Yes, Your Honor.
All right. And you understand that just because you're agreeing to this, that this isn't an admission of, or that you're agreeing to the SOC, it's not an admission of guilt. It's simply a arrangement for whatever reason between you and the state.
Correct. Yes, Your Honor.
All right. Do you have any questions about this arrangement?
No, Your Honor.
Do you feel you're entering this freely, knowingly, and voluntarily?
Yes, I am, Your Honor.
All right. If that's the case, I will find that you know what you're agreeing to. I will, oh, there's one more thing, and I believe TCPD, including your attorney, Mr. Pizderka, would have told you about this, but I want to make sure. There's one subsection that people tend to gloss over, which is that you're also agreeing as part of this arrangement to notify the court of any address changes for the duration of this contract. Do you see any issue with that?
No, Your Honor. I do plan to notify of a change of address soon.
Fantastic. And do you see any reason you won't be able to uphold your end of this arrangement?
No, Your Honor.
All right. If that's the case, I will find your entering this freely, knowingly, voluntarily, that you should be able to uphold this based on your representations. And I have filled out the form, affixed my signature. Congratulations. Welcome to the SOC program. I hope it treats you well. I've also filled out the JNS. If you need copies of any of this paperwork, please get that. You can get that online or speak with your attorney. They can help you if you have any questions.
Okay.
Otherwise, sir, I wish you a good day. You are free to go, and congratulations.
And Your Honor,
You
I
as well.
have just moved
Thank you, Your Honor.
the rescission order to the judge's folder.
And Mr. Getchell, I am also signing off on a rescission of a no contact order. No contact order, right, counsel?
Yes.
Being as apparently Adobe now needs to install an update.
Does that mean the current no contact order will continue?
Mr. Getchell, no, it means it's going to be rescinded, which is to say it's going to be removed. That said, if there is ever a form that you need to get a copy of, it is this one. Just because I have signed this paperwork and filled it out does not mean that every law enforcement agency in the state will have access to it immediately. Sometimes these things can get stuck in the computers for a day or two. You will want to get a copy of this from the court website as soon as you can. Keep a printed copy of it with you for a couple of days. That way, if there are any questions or concerns, you can show proof that this order has been revoked. After about 48 hours, it's usually in all of the computer systems. I just want to give you that heads up.
Okay, thank you, Your Honor. I would just like to ask, is that through the Laserfish filing program? I've been obtaining my court records through that.
Yep, you'll find it in there.
Okay,
It
thank
has
you,
my
Your
signature
Honor.
on it now. You'll be able to find that shortly.
All right, thank you.
You have a good day, sir, and congratulations.
Thank you, Your Honor. You as well. Am I
All
free to leave?
You're free to leave. Thank you for being here. Mr. Pizderka, who would you like to call next?
Yeah, did we call Michaela Clark next? And I apologize. She's on the 9 a.m. calendar.
All right. Good morning, Ms. Clark.
Good morning.
All right.
Your Honor, I will be appearing on behalf of Mr. Kale this morning, and the intention is to enter into a plea, and that plea should be in the judge's folder.
All right. And counsel, you said this is on which calendar? I'm sorry, I've got a very long calendar I'm flipping through today.
It is on, sorry, I apologize, 9:30 calendar number 6.
Fantastic. Thank you. All right. Why am I not seeing there's 9:30? All right. And good morning, Ms. Clark. I want to go through this all with you, your attorney, all of that. But first, I just want to double check. Is it your intention to enter a plea today?
Yes.
All right, excellent. Mr. Pizderka, would you like to make a record?
Your Honor, only to say that it's my understanding that Ms. Clark went over the plea form with Mr. Kale. She's been advised of her rights and has no further questions.
All right. Fantastic. If that's the case, Ms. Clark, I've got before me a statement of defendant on plea of guilty. It's my understanding it's your intention to enter a plea today. That said, I do want to review some of this paperwork with you. So first and foremost, you've mentioned it's your intention to enter a plea. I want to review. Is your true name Michaela Sativa Clark?
Yes.
And are you 22?
Yes.
All right. You've completed the 9th grade?
Yes.
All right. It looks like you're currently charged with reckless driving and reckless endangerment. Is it your understanding that that's what you're currently charged with?
Yes.
All right. Do you have any questions about what the definitions of those or crimes are, or what the prosecution would have to prove at trial should you decide to go that direction?
No.
Okay. If you enter a plea today, you'll be giving up your trial rights, and those are important constitutional rights, so I want to review those. Those are the right to a speedy and public trial by an impartial jury of your peers in the county where the crimes alleged to have taken place, the right to remain silent before and during trial, and the right to refuse to testify against yourself, the right to question witnesses who testify against you, the right to bring witnesses to testify on your own behalf at no expense to you through the subpoena process, the presumption of innocence until proven guilty beyond a reasonable doubt, or the entry of a plea, and the right to appeal a finding of guilt after trial. If you enter a plea today, you'll be giving up those rights. Do you have any questions about those?
No.
All right. And you understand you'll be waiving those?
Yes.
All right, excellent. It looks like an arrangement's been reached between the prosecutor and your attorney. It states that in exchange for a plea of guilt, the prosecutor will make the following recommendation to me at sentencing, which will be 364 days of jail with all 364 days suspended for 24 months on both counts. State will dismiss charge 21-1-00499-34 with prejudice upon entry of a plea. And counsel, just for ease of communication, what is that? I don't have that information.
That is an attempting to elude Superior Court matter. This is downfiled, and the agreement was to plea as charged to these 2 counts. In agreement, the state would dismiss the Superior Court matter.
Fantastic. Ms. Clark, is that your expectation of what they're going to be offering?
Yes.
All right, and you excuse me, there will be an expectation during this time that you'll have no new criminal law violations. You'll not drive without license and insurance.
Yes.
All right, and you understand that just because that's the recommendation doesn't mean I have to follow it. As the judge, I can give you from the minimum sentence all the way up to the maximum, and same with any fines or restrictions.
Yes.
All right. It looks like you've had a chance to speak with your attorney about any potential immigration ramifications, but do you have any remaining questions for your attorney there?
No.
All right. Do you have any, there will also be an impact to your driver's license. Do you have any remaining questions for your attorney about that?
No.
Okay. If that's the case, there's a section here called a statement of facts. It's a formal statement you'll be adopting as part of your plea. It states that on May 29th, 2021 in Thurston County, Washington, I drove a vehicle in willful or wanton disregard for the safety of property and recklessly endangered in conduct that created a substantial risk serious physical injury to another person. Are you willing to accept that as your formal statement?
Yes.
All right. Do you have any remaining questions for your attorney or for the court?
No.
Do you feel you're making this plea freely and voluntarily?
Yes.
Has anyone threatened you or anyone you care about to get you to enter this plea?
No.
Has anyone made any promises of any kind other than the offer itself to get you to enter this plea?
No.
If that's the case, do you feel you're making this plea freely and voluntarily, ma'am?
Yes.
All right. If that's where we are at to the crimes of reckless driving and reckless endangerment, how do you plead?
Guilty.
I understand. I will find that you're making this plea freely, knowingly, and voluntarily. We'll move to sentencing. And I'm affixing my signature to this form. I do find that this plea has, excuse me, I find that this has been entered knowingly, freely, and voluntarily, and I do find the defendant guilty as charged. We'll move to sentencing. Mr. Pezderka, would you like to make a record?
Yes, Your Honor. We would ask you to follow the negotiated agreement. We believe it's fair. It was heavily negotiated between the parties, and would finally ask that you waive any costs or fees associated with this case, including the $43 conviction fee. Ms. Clark is a mother of 3. She currently receives food stamps and TANF, and to that end, would be considered statutorily indigent, which is a basis to waive even the $43 conviction fee under the statute. Other than that, I would just reiterate that we would ask you to follow the agreed recommendation. Thank you.
All right. Counsel, would you like to make a statement?
Your Honor, this was a case that was in essence downfiled from Superior Court, and this was a negotiation that happened up there. This was brought to our desk, and by and large, the negotiations have already been done. I think it's appropriate, and I would just ask that the court follow it.
All right. Ms. Clark, you have what's called the right of allocution, which is to say, now that the attorneys have done their work, you have the final right to make a statement if you so desire. That said, or before I enter my final sentence, that said, I'm not going to hold it against you if you do not wish to make a public statement. Public speaking is not for everyone, and I don't wish to put you on the spot. I understand that right now is an emotionally difficult time, no matter for everyone. Would you like to make a statement for me to consider before I enter a sentence? All right. I see you shaking your head no. I'm going to understand that you don't wish to make a statement. If you can give me a thumbs up that was your intent to communicate. Yeah, thank you. Sorry. All right. I will say for the record that Ms. Clark has indicated she does not wish to make a statement at this time. And as I said, I'm not going to hold that against her. Public speaking is not easy. At this time, I'm going to follow the recommendation. I will impose 364 days of jail on both charges and suspend all 364 days under conditions of no new criminal law violations and not driving without license and insurance. Ms. Clark, I'm not going to impose any fees. I don't believe it is within the interest of justice to tack on any additional requirements here. Simply don't have new criminal law violations and don't drive unless you have license and insurance. And that is going to be it for your requirements. If you violate those requirements, additional time may come back, but otherwise you will not be expected to serve jail time. At this time, the sentence will be effective until February 14th of 2026, that 2-year period. Ms. Clark, you will be on monitored probation, which is to say simply that the court will check your file to make sure that you have no new criminal law violations. which would include a driving without a valid operator or with a license suspended. So keep on top of any licensing restrictions. If you have any questions about that, please speak with your attorney. I know you've had a chance to review it, but those licensing restrictions can be confusing and they don't just automatically come back. There are affirmative things you'll have to do. So just because the 30 days is up, that doesn't mean that your license will be fully back. Remember, I don't want you to come back in a year and a half because you got pulled over and it turns out that, there was one piece of paperwork you needed to sign or something like that. Otherwise, ma'am, I wish you luck. I've affixed my signature to all of the paperwork. And congratulations. And before you go, I am granting the state's motion to dismiss the Superior Court matter as was motioned. I want to make sure that that's on the record. Otherwise, Ms. Clark, I wish you a good day. I hope the rest of your day is easier than the last hour has been. Thank you for being here this morning.
Thank you.
All right. Mr. Bezderica, who would you like to call next?
Yes, Your Honor, we would call numbers 14 and 15 on the 9 a.m. calendar. Ricardo Rivera. I will be waiving his appearance this morning. He was present on Zoom earlier, but needed to jump off for work. At this time, we are just asking to keep the further trial dates and trial dates and plates. Negotiations are currently ongoing between the parties. And we would ask that the FTC matter track alongside the new matter.
All right. State, anything I should know or any objections?
Your Honor, city's in agreement.
Oh, city, excuse me. All right. We'll strike today's date and we'll let that move on to the trial confirmation. I wish you luck, Mr. Bezderica.
Thank you. Next, Your Honor, we would call number 12 on the 9:30 calendar, Patrick Waters. The president on Zoom, and I believe it's my understanding that the state has a motion.
All right. Good morning, Mr. Waters. There he is. Mr. Waters, are you able to unmute your mic and turn on your camera? All right. Mr. Bezderica, perhaps we can give Mr. Waters a moment to oh, there we are. All right. Good morning, Mr. Waters.
Good morning.
All right. Mr. Waters, thank you for being here this morning. Your attorney has indicated that the state this time has a motion that they would like to make to you, Mr. Fortunato.
Your Honor, the state is making an oral motion to dismiss the charge ending in 2165 without prejudice.
All right. The court will grant it. Mr. Waters, the state has requested to dismiss the current charge against you. The court has granted it. You are free to go. Thank you for being here this morning.
Thank you.
All right.
And
All
Your
right.
Honor, all I have prepared, I would defer to other counsel at this time.
All right. Mr. Stillwell, I see you're connected. Oh, Ms. Lesh, there we are. Who would you like to call next, Ms. Lesh?
Yeah, just have one quick matter, and that's number 11 on the 9:30 calendar.
All right.
Mr. Schweitzer.
I'm sorry, could you say that again?
Mr. Schweitzer.
All right. And is Mr. Schweitzer present today?
He is present over Zoom.
All right. Good morning, Mr. Oh, there you are, Mr. Schweitzer. I mentioned something to you earlier. Good morning.
Good morning.
And counsel, how are we proceeding today?
Thank you. I'm standing in for Attorney Capone on this matter. We're simply asking to keep the future dates as set. Confirmation set for March 13th, 9:30 in the morning.
State, anything I should know?
State is in agreement, Your Honor.
All right. Mr. Schweitzer, I know it's not fun to sit here and listen to the court talk for some time to quite a few other people when you've been here all morning, just to say, come back another time. But sounds like at this time, we're just going to continue on to your next court dates. I wish you luck in navigating this process and thank you for being here this morning.
Thank you, Your Honor.
You have a good day, sir. All right. And counsel, who would like to call next?
That is all the matters I have at this time.
All right. And counsel, before you go, if I could ask a favor, I believe I asked this of Mr. Pizderka as well, but I know Mr. Nesbitt is sitting, or if you could make sure Ms. Simmons is aware.
Thank you. I did let her know. I believe will be here as soon as possible, and she's in courtroom number 2 at the moment.
I appreciate it. All right, thank you. Mr. Stillwell, are you available to take any matters at this time? All right. As Ms. Lesh and Mr. Pizderka both just called matters. Mr. Pizderka, if you have anything else we can address this time, otherwise we'll recess.
Matters, I don't believe my clients have appeared. Number 8 on the 9:30 calendar, Sean Parasol. I don't have any representation at this time.
You said number 8 on the 9:30?
Yes, Your Honor.
Mr. Meeker, I've got. Is that correct?
No, sorry, 9 a.m. I apologize. Number 8 on 9 a.m. Sean Parasol. I apologize.
All right, Sean Parasol, I see it. All right, counsel. You have no representations at this time, state? Are you seeking a warrant?
Your Honor, I see Mr. Pearsall has 3 active warrants, 1 out of Olympia Muni, 2 out of Aberdeen Municipal, including $1,000 to $1,500 warrants. State's going to be asking for a bench warrant to be issued in the amount of $1,500.
All right, Mr. Pizderka, any argument?
No, Your Honor.
All right. At this time, the court is going to find that there's no less restrictive alternative than to issue a warrant for Mr. Parasol's appearance. Hopefully that can get him before the court. We will issue it for $1,500. All right.
I did have one other matter. The 9:30 calendar, number 1, Joey Beaver. I also have no representations as to his non-appearance this morning.
All right, number 1 on the 9:30, Mr. Beaver, you said you have no, just making sure, counsel, I apologize, the audio is still a little tetchy after the issues that I had the other week. You said no representations?
That's correct.
All right. State, so that is the same question back to you. Or do you intend to seek a warrant this time?
Your Honor, I see Mr. Pearsall or Mr. Beaver has 5 active warrants out of Olympia Municipal, each for $100. Would ask for a bench warrant to be issued in the amount of $100.
All right, Mr. Pizderka, any argument?
No, Your Honor.
All right, counsel, although I appreciate your argument for $100, I don't believe that at this time such a low figure is going to do much to get Mr. Beaver in. The court's going to issue $1,000. Hopefully that is enough to get law enforcement to hold him the next time they interact with him. The court will issue a warrant. I don't believe there is a less restrictive alternative available. All right. Mr. Pizderka, any other matters that you can address? I appreciate your willingness to do so far.
I don't believe so, Your Honor.
All right. Madam Clerk, you mentioned having spoken with Ms. Rowe. Do you know if she's coming back for other matters?
She is supposed to come back. Sounds like she's in.
Okay. If that's the case, I'm not going to deal with any of hers, but I am going to start with FTCs or FTAs on the 8:30 calendar. First off, David Erickson. I see that this is one of Ms. Lesch's. Ms. Lesch, do you have any representations you can make to the court at this time?
Unfortunately, I do not.
All right. Counsel?
Your Honor, I see Mr. Erickson has 2 active warrants, including a Kirkland Municipal warrant for $75,000. I'm going to be asking for a bench warrant to be issued the amount of $5,000 cash bond.
Ms. Lesch, any argument?
But no information to share.
All right. The court will find there is no less restrictive alternative than a $5,000 warrant. I'm impressed by the appellant's refusal to get before the court in multiple matters in multiple counties, but not in a positive sense. We will issue a $5,000 warrant. I believe there is no less restrictive alternative. All right. And we've got multiple matters on under different causes. All right. So we will issue 5,000 on each, I think is the way to handle that one. And I see that Ms. Rowe may be coming in, but I'm just going to go down the list until she's ready. Good morning, Ms. Rowe.
Good morning, Your Honor. I've been bouncing back and forth between the courtrooms.
So the court understands everything you're going through, Ms. Rowe, and appreciates your ability to juggle these multiple matters. Did you have any matters you're ready to call at this time, Ms. Rowe?
Yes, Your Honor. If we could call Avril Boyce.
All right. And is Ms. Boyce present today? I'm not seeing them. All right. Ms. Boyce does not appear to be present at this time. Counsel, any representations?
Your Honor, I would ask that the court waive Ms. Boyce's presence and simply proceed to the March 15th court date. In full disclosure, however, Your Honor, I have not personally spoken with Ms. Boyce. I did leave a message on her message machine, so I don't want to, to misrepresent anything to the court. I haven't talked to her, but I do see that we have a hearing set for March 15th. I would ask the court just to note the FTA today and proceed to that court date.
All right, State.
Your Honor, I see that Ms. Boyce has had warrant, and not only has warrant history, but has previously had a warrant issued on the 23-M00011 cause number. This warrant was issued on December 12th and was returned on December 26th. With that, I think it's appropriate to request bail. I'm going to be asking for a bench warrant to be issued in the amount of $5,000 split between both cause numbers.
Past activity, okay. Counsel, one more time, or I suppose Ms. Rowe, any argument?
None that I haven't made already, Your Honor.
All right. Ms. Rowe, how recently did you leave that voicemail?
I left the voicemail yesterday, Your Honor.
All right. Bear with me just a moment. All right. Counsel, if there were not new charges since the warrant matter, I would not be so. The court would be more willing to give some understanding to the difficulty of getting a client on the phone. At this time, however, the court is going to issue a warrant for $1,500 in both matters. I see no less restrictive alternative to secure Ms. Boyce's appearance, and it appears that while there was an active matter with a requirement of no new criminal law violations, a new allegation has come down. It does not appear to be in violation of the actual no contact order, but nonetheless, the court is concerned by the continued behavior. I don't believe there is a less restrictive alternative, and so warrants will issue. All right. Ms. Rowe, are you able to, I want to try and at least knock out the 8:30. Can you address the Christopher McGillimore matter at this time? Sorry, Christopher.
Yes, Your Honor. Your Honor, unfortunately, Mr. McLemore's case is the same situation. It appears that I left a message yesterday. No, in fact, I called yesterday 2 different numbers. I was not able to leave a message. One number wasn't good and the other one just rang and rang with no. Hello?
All right.
However, also the same as the last case.
Christopher McLemore is here.
Okay.
Hello?
Hi, it is currently shouting. I see that your name is set to Amanda Bricker. If Mr. McLemore is there, that is good to know. If you can turn on a camera. That said, please refrain from yelling curse words when your mic is not muted.
Sorry, he thought it was still
The court
muted,
does
and
not
I'm
want
trying
an
to figure out how to
explanation
get the
as to
video on.
I don't need any explanations. I see you're here now. I think that, so you, sir, are Christopher McLemore?
Yes, sir.
All right. Excellent. And my understanding is, Ms. Rowe, you've not had a chance to speak with Mr. McLemore yet?
That's correct. If I could have Mr. McLemore grab a pen, I'd like to give him my number.
All right. Mr. McLemore, this is Ms. Rowe.
I will do that. I got a pen and paper right now, so.
All right. If
My
you can
number
take down.
is 360-209-6814.
Okay.
If I could have you call me at noon, I'd appreciate it.
You said
And
360-209-14.
209-6814.
Can you repeat that one more time? Sorry, I'm not catching you.
209-6814.
Okay. Thank you.
Your Honor, in regards to the case, we have confirmation currently set for March the 15th. We're simply asking the court to proceed to that confirmation date.
State, any objections?
State's in agreement, Your Honor.
All right. Mr. I wish you luck in speaking with Ms. Rowe. Please give her a call at the time she indicated. I believe she said at noon. Otherwise, your case will move on to the
Can
next.
I go down to the public defense office and speak with her in person? Does she?
Mr.
Is she
McLemore,
there
you
during the
give
week?
Ms. Rowe a call. She is the one who can help you negotiate
Okay.
that. That's for her to decide. All right. You have a good day, sir. Thank you for being here.
All right, thank you.
Except for the next court dates.
All right, thank you.
Your Honor, I'm going to need to pop over to courtroom 4. If the court can pass on me, I will be back.
All right.
Defer to Ms. Simmons there.
Thank you, Ms. Rowe.
Ms. Simmons, you need a breakout room, I suspect?
Not at this time. I have Elizabeth Mayoral, who's been waiting patiently on Zoom. She is number 4 on the 9 a.m. calendar, here for her first pretrial today.
All right. Good morning, Ms. Mayoral.
Good morning, Your Honor.
All right. And counsel, how would you like to proceed?
Your Honor, I believe Mr. Fortunato has a motion.
That's correct, Your Honor. The state is making an oral motion to dismiss the charge without prejudice.
All right. Ms. Simmons, I assume no objection.
None, Your Honor. There is also a tracking infraction.
All right. And how are we handling that?
Yes, Your Honor, the tracking infraction, case number 3A0793587 is also dismissed upon. Ms. Mayoral has now fully licensed, had her full license reinstated, so that would be the basis for the dismissal, Your Honor.
All right. Ms. Mayoral, it seems that the state is dismissing the allegations against you. Congratulations. I wish you luck. And thank you to Ms. Simmons for your help in navigating this. All right.
Thank you.
You have a good day, ma'am.
Thank you,
All
Ms.
right.
Mayoral. Take care. Thank And Your you. Honor, I'll defer to Mr. Stillwell.
Ms. Simmons, before you go, Mr. Nesbitt is present in the courtroom if you'd like a breakout room.
And I understood he did have a phone or doesn't have a phone. I provided my phone number. I'm not sure that.
Mr. Nesbitt, do you have a phone on you?
I do. I was told that I would be contacted by her and I should go ahead into a breakout room after I was.
Okay. Ms. Simmons, would you like to have Mr. Nesbitt give you a call or to give Mr. Nesbitt a call?
I don't have his number, so he would have to give me a call unless he'd like to provide that. Either way, Your Honor.
How about we have Mr. Nesbitt give you a call. Mr. Nesbitt, I appreciate your patience. I know it's been a long morning already. If you could step outside and give Ms. Simmons a call, you're welcome to do so in the hallway. However, sometimes this reception in this building can be a bit spotty, so feel free to step out and come back. I'm not going to mark you as not here. Yep. Good luck, sir. All right. Oh, Ms. Mayoral, you are free to go unless you would like to observe the court. You're not required to. Mr. Stillwell, good morning.
Good morning, Your Honor. Thank you, Ms. Simmons. I've got two quick matters. If he's still present in the courtroom there, I can call Mr. Daniel Bensner, who is numbers 2 through 5 at 9:30.
And good morning, sir. Thank you for your patience this morning. All right. And counsel, how are we proceeding today?
Your Honor, we're asking for the pending matters to simply keep the confirmation date on March 6th. And I believe there's a tracking preliminary FTC matter as well, asking that just continue to track along with these cases. I recognize the dates of offense here are a couple of years old. I was just assigned, I believe, last month. So we're still need to meet and get going on the case.
All right. State, any objections?
No, Your Honor, state's in agreement.
All right. Sir, I know it's not fun to sit here and just listen to attorneys talk all morning, especially just to be asked to come back later, but we're going to let this move to its next hearing.
All right.
That said, in the interim, do you have Mr. Stillwell's contact information?
Yes, sir.
Perfect. Then I don't need to get that for you. Otherwise, you're free to go. I appreciate you for being here this morning. And I will find there's good cause for this continuance. I see Ms. Tammy Shoefield's still connected to this, and that's not a name I've seen associated with public defense in quite some time. All right, you two have a good day. Thank you for being here.
I'm sorry, Mr. Stillwell, was that a continuance or was that just keeping the dates?
Oh, excuse me, that was
Okay.
keeping the existing dates. I misspoke.
Perfect, thank you.
All right.
And then the one other matter I have is Miss Tana Morgan, whose numbers 9 and 10 on 9:30.
All right.
And Miss Morgan is she is technically in custody at Thurston County Corrections Facility, but she is off at a treatment furlough at ABHS in Spokane. I talked to her counselor yesterday. Her expected graduation date for her treatment program is February 22nd. I've contacted the district court in custody clerk about putting her on the in custody calendar Friday, February 23rd. Speedy trial on this case. That is after the jury trial dates, but speedy trial doesn't expire until Monday, February 26th. So we're still within that time frame. And so I'm asking that both her matters be set on the directly at the 1:30 calendar on Friday, February 23rd for resolution.
Wow.
All right. Would that work for you, Burnett?
Yeah, it'd be sensitive.
All right, Mr. Stillwell, I'm being told that if you've sent that to the in custody clerk, they'll get it taken care of. I have no issue with striking today's trial dates or hearing date unless, Mr. Fortunato, do you have any wildly conflicting news that I should be aware of?
No, Your Honor.
All right, excellent. We'll make sure that that's the case then.
Thank you, Your Honor. Thank you, Counsel.
Yep. Just want to, so I see on the 23-M00342 matter that there are trial dates set for the 21st and 22nd. Are those dates to be stricken?
Ooh, that's a good point. Yes, we'll strike the trial dates. If it does not make much sense to the court to have, well, to drag anyone here while they are still in furlough treatment. So we will strike dates and get ones, and we'll simply leave it to that one. What is that? That 2/23 date. For trial confirmation work for everyone, or should we do another free trial?
Confirmation should be fine. Yeah.
I'm sorry, Mr. Stillwell?
No need to reset a pretrial. Confirmation should be fine.
All right. Excellent. But we will strike those jury trial dates. Thank you for that, counsel. I appreciate the heads up. All right. Mr. Stillwell, any other matters you can address this time?
No, that's all, Your Honor. Thank you much. I'll defer to other counsel.
All right. Welcome back, Mr. Pezderka.
Your Honor, I have one final matter on the 10:30 count with the dean, and she's present on Zoom. That's for pre-trial.
All right.
And at this time, we are just asking to leave the further dates in place. Negotiations are ongoing.
All right. Ms. Dean, do you have a camera you can turn on? Do you want to mute your mic?
Yes.
And good morning. Thank you for being here today.
Okay.
All right. Mr. Fortunato, did you hear Mr. Pesterica's intention there?
I believe so, just to keep the current dates and states in agreement, Your Honor.
All right. Ms. Dean, I thank you for being here this morning. We are going to keep your next dates in place. I wish you luck in navigating this process. Thank you for being here. All right. And you're free to go. I know it's unfortunate to hop on for such a short hearing, but we appreciate it. And take care. All right. Mr. Pazderka, if that's the end of your matters on this calendar.
Yes, but I did realize that maybe one more I could call on behalf of Mr. Kale on the 9 a.m. calendar, number 17, Jake Summers. If that, I don't believe that was addressed by Ms. Lesh. If I could just confirm, and then I can.
Correct. Mr. Pazderka, the 17 and 18 on the calendar, Mr. Summers' matters have not been addressed.
If we could call those, I'd appear on behalf of Mr. Kale and let the court know that he has no representations at this time.
All right. State, what are you seeking a warrant at this time for Mr. Summers?
Your Honor.
No worries.
Your Honor, I do see Mr. Summers has 2 active warrants, one out of Lewis County and one out of Olympia Municipal. I also see that these cases have been on warrant status previously, both of them. Additionally, they are noting the 2021 date, fairly old cases. With that, the state's going to be asking for bench warrants to be issued in the amount of $2,500 on each case.
All right. Mr. Pazderka, any argument?
No, Your Honor.
All right. The court will issue a $2,500 warrant on each matter. It does not appear Mr. Summers is particularly interested in appearing before the court without a warrant being issued. I will find that there is no less restrictive alternative to secure his appearance. Mr. Pazderka, before you go, I do appreciate you being here this morning. Just because you've been sitting in on some of Mr. Gale's matters, do you have any information on the Cody Sanders matter? Are you able to address that?
I am able to address it and stand in for Mr. Kale. Similarly, however, I have no representations as to his non-appearance.
Okay. Thank you for addressing that, counsel. State.
Your Honor, I apologize. Which matter was this?
Cody Lynn Sanders, number 10 and 11 on the 8:30 a.m. calendar.
Okay. Your Honor, I do see Mr. Sanders has a active bench warrant out of Kent Municipal Court for $5,100. Additionally, I see that this matter has been on warrant status previously. State's going to be requesting a bench warrant to be issued in the amount of $1,500.
All right. Reviewing this file, it appears that Mr. Sanders does not appear before the court without the issuance of a warrant. There also appear to be quite a few issues with FTAs in multiple counties, in addition to active warrants and warrant history all over the place. The court is going to issue a $1,500 warrant on both of Mr. Sanders' matters. All right. Thank you, Mr. Pazderka, for being here. Are there any other of Mr. Kale's matters you're able to address by chance?
I believe that was all of them. I believe they've all been called. So
I think you're right about that. If that's the case, thank you for the extra help, Mr. Pazderka. I appreciate it every time someone stays on as a friend to the court, which I have kind of assigned you, but I appreciate it nonetheless.
Yeah.
All right. Have a good day, sir. All right. Ms. Lesh, any matters you're able to address?
Only matters that I have left on this calendar are numbers 1 through 3 on the 11 o'clock calendar. And given that it's not quite 11, I just ask that we give Ms. Hand some more time.
Absolutely. And bear with me just a moment, Ms. Simmons. Ms. Schubert, I don't need you to unmute yourself, but I do want to say we're waiting on your attorney who's currently having a conversation in another courtroom. I do appreciate your patience. The court is not going to mark you as absent or anything. We appreciate your patience. All right. Ms. Simmons.
Thank you, Your Honor. Ashram Nesbitt, I hope I'm pronouncing that correctly, is present in the courtroom. He is number 7 on the 9 a.m. calendar here for his first pretrial today.
Counsel, I would love to call him. However, he is not currently present in the courtroom. I think he's probably on his way back. I'm hearing doors opening and closing, so I think we'll
All
see.
right,
shortly.
thank you, Your Honor.
In the meantime, are there any brief matters? Nope. Here is Mr. Nesbitt. Welcome back, sir. And Ms. Simmons is ready to hear your case. If you'd like to come forward and take a seat up here, we can hopefully get you out of here. Right. And good morning, sir. Thank you for being here today, and thank you for wearing a suit. The court appreciates it.
Thank you for noticing.
Yep. All right. Ms. Simmons, how are we proceeding today?
Hey, Your Honor, Mr. Nesbitt and I have set an appointment to meet. We just want to keep those dates that are already assigned. We have a jury trial confirmation on March 15th.
All right. State, anything the court needs to know?
State's in agreement, Your Honor.
Fantastic. All right, Mr. Nesbitt, I appreciate your patience this morning. I know you've been here for a very long time to be before the court for a very little amount of time, but we will go on to your next court date. I wish you luck navigating the court procedure, and I hope Ms. Simmons is a good aid to you. She's a good attorney. You're in good hands, but I wish you luck.
Thank you for helping me navigate this.
Yep. If I did anything, I'm happy to have done it. Otherwise, I hope you have a good day, sir.
You as well. Bye, everyone.
Take care, sir.
Thank you.
All right. All right. Ms. Simmons, any other matters you can address at this time?
No, Your Honor, that's all I have. I'll defer to counsel.
All right. Actually, Ms. Simmons, I don't suppose it's 10:43. Can you address, are you able to address the David Rogers matter?
Certainly, Your Honor. Just a moment. Let me get my calendar. Sorry, Your Honor, Mr. Rogers is my client. I didn't have him highlighted here. If the court would give me just one moment.
No worries. And counsel,
Thank
while
you.
you're looking at that, if you could also, if you haven't marked it, the Brandon Systema matter is also one of yours. And
Mr.
that looks,
Oh, sorry, Your Honor. I apologize for interrupting.
no intent. It was clearly not an intentional thing. Are you able to address either of those matters, or would you like a couple of moments?
Mr. Sitzma actually should have been moved to the afternoon calendar as he is in custody in Thurston County.
Oh. Counsel, do you have any conflicting information there?
No, Your Honor.
All right. Brendan Systema, numbers 5 and 6 on the 10 a.m. calendar appear to be currently in custody. So we will strike that. Thank you for letting us know, Ms. Simmons.
You're welcome.
All right. And someone has just entered the courtroom. May I have your name, ma'am?
Hand.
Ms. Hand? All right. Ms. Lesh, Ms. Hand has just appeared. Thank you for being here this morning, Ms. Hand. Do you need a breakout room, Ms. Lesh?
We would appreciate that, yes.
All right. Ms. Hand, we're going to give you an opportunity to speak with your attorney before this hearing. Can we get the thing set up? Okay.
I can walk her out there though.
Yeah, if you'd be so kind. We'll take a brief recess. We'll get you an opportunity to speak with your attorney, Ms. Hand. And Madam Clerk is going to show you the right room to be in.
Thank you.
All right, the court is on a brief recess while we wait for Madam Clerk's return as she helps them with a breakout room. Counsel, I don't suppose you have any other matters to dismiss we could address quickly.
None at the moment, Your Honor.
Understood.
Your Honor, if the court did want to proceed with David Rogers.
I would love to, counsel, but I do not yet have a court clerk, so I need to wait to make sure that we're not causing her any despair.
I would hate that to happen. Sorry about that.
No worries. All right. Thurston County District Court will return from its very brief recess. All right, and I see that someone has just joined under the name Jonquil Vigado. That's the VA. I'm sorry. Excuse me, I will not bother you. All right, Ms. Simmons, if you're ready to address the Rogers matter.
And Your Honor, this would be Mr. Rogers' first pretrial on his driving with license suspended in the third-degree charge. I don't have any contact information as to telephone number, and I have no representations to make to the court on this matter.
Counsel?
Your Honor, I see Mr. Rogers has no active warrants, and given the nature of the charges, there's no objection to setting this over. I do see that it's currently set for a date on March 13th. The DPA assigned to the case is currently out of the office studying for the bar. Hopefully at that amount of time, he and counsel can contact and negotiate on this case. I do think that that's entirely likely given the nature of the charge. I would just ask that dates remain and note an excluded period through the next date.
All right, we are going to note the FTA simply as Mr. Rogers does has quite an extensive history, but we will happily just let this move on to the next date and note the excluded time. Good luck, Ms. Simmons. I hope that Mr. Rogers reaches out, but given that he has no active matters, hopefully he gets the memo. And hopefully the letters the court sent him that have not been returned lead to some communication.
Thank you.
All right. Any other matters you can address, Ms. Simmons?
Not at this time, Your Honor. Thank you.
That's actually, Ms. Simmons, I don't believe I've got anything else on the calendar for you unless I'm missing something.
I don't believe so either, Your Honor.
All right. Well, then you are free, of course, to hang around if you so desire, but don't let the court hold you. All right.
Thank you, Your Honor. Enjoy your Valentine's Day. Thank you, Counsel, Madam Clerk. If
Thank
she's
you,
back.
Jerry.
Take care.
Welcome.
All right. Mr. Stillwell is currently not in here. I believe he's in a breakout room. I'm certain that Ms. Rowe is in another courtroom and Ms. Lesh is speaking with Ms. Hand. And I believe we're largely caught up on FTAs. Counsel, have I missed any FTAs that aren't Ms. Rowe's from earlier on? But we've largely worked through this calendar.
I don't know if Mr. Stillwell is in a breakout room with Miss Sayers Hartman.
Okay. All right. I guess counsel did not object to their own non-presence. So counsel, unless you have objections to a waiver.
I would anticipate that Mr. Stillwell has had communication with his client based on that representation. I would just ask that dates remain and echo the request of counsel.
Fantastic. Court will grant that. We will waive Ms. Sayers Hartman's appearance and leave the remaining dates. And otherwise, we are waiting on Ms. Rowe and Ms. Lesh. Let's see. All right, and to Ms. Schubert and to Ms. Van Meerbeck, your attorney, Ms. Rowe, is currently in another courtroom. She will be with you as soon as she can, but the court does appreciate your patience while she handles another matter. As soon as she's available, we'll make sure you have an opportunity to work with her. Thank you for your patience. Please hang on until then. The court sees someone coming in. All right. The court's going to be on recess. Let me know when y'all are ready for me.
Okay, 1 second.
The court will go on recess. I'm going to be in the back room. Let me know when someone's ready.
Okay, sounds good.
Mr. Fortunato, if for some reason both of us are out and Ms. Rowe returns, please make sure she knows that we're ready.
Certainly, certainly. Thank you. I will just let you know, I'm the attorney for the state, so if you talk about anything with this matter, I really can't hear it.
I just wanted to find out about
bail to be changed over to PR, whatever it is, we guys speak.
So if you want to talk about bail, I would recommend, is this for your own case?
So it's for my wife.
I would recommend she talk to her attorney about that.
Okay.
That, I can say with limited understanding, obviously being from the state,
Yeah.
typically when a case resolves, the bail amounts will be either forfeited or will be returned. I don't know exactly. But I would again recommend she talk to Ms. Lush about that. She'll have a lot more information to share with her about it. Yeah.
I just talked about that, so it's like.
Yeah. Yeah. Yeah, good idea. Yep.